Welcome to the 38th Annual Duke Law Journal Administrative Law Symposium. This symposium throughout the years has helped to form our understanding of administrative law and sometimes its very trajectory. And we know that this year will not be any different. When we planned the symposium for April 15th, I don't think we realized the irony that this is the day that most Americans find themselves most affected by administrative law. But I know that some of the classes are not going to end until 4:30, so there'll be people coming in and out throughout the day. There are refreshments outside if you need anything, coffee, tea, and water, and we hope that all of you will stick around for the reception that we're going to have at 7. Without further ado, I would like for Jonathan Paul, the editor-in-chief of the Duke Law Journal for Volume 57, to come and introduce the speakers and the sponsor for this event.
Thank you, Destiny, and thanks to everyone who's here. Really pleased to have a distinguished panel of guests speaking today about our topic. Pleased also to have the support of Jones Day, some attorneys who are here. They have quite graciously helped to sponsor this event, and we thank you very much for the support. Want to start off just by mentioning a little bit about the topic, which I think has spilled out into something significantly more than an academic debate. Probably didn't spill out. It started as something more than an academic debate and has grown over the last few months and even weeks. The Supreme Court this year has focused on a agency preemption case in Riegel against Medtronic. They're focusing on a case again next year, Wyeth against Levine. And they've also, other courts as well have also addressed this issue. The Third Circuit Court of Appeals just came down with a decision last week, a case called Apotex, which also addressed some of the preemption issues that are being discussed today. These cases are before the courts. They're also before the public. I don't know if all of you saw the New York Times editorial piece in yesterday's paper arguing against preemption in many of these cases. A lot of the focus has been on FDA cases, decisions focusing on the Food and Drug Administration. But the preemption debate is much broader than that, and I hope that we'll get a sense of that during today's talks. I'd like to go ahead and introduce our guests today. Mark Seidenfeld is the Patricia Dorr Professor of Administrative Law at the Florida State University College of Law. He teaches in administrative law, constitutional law, environmental law, law and economics and regulated industries. He clerked for Patricia Wald on the D.C. Circuit Court of Appeals and is the chair of the Judicial Review Committee and vice chair of the Rulemaking Committee of the ABA section on administrative law and regulatory practice. Professor Brian Galle is assistant professor of law at Florida State University College of Law as well. He teaches in the areas of tax and broader administrative law issues. He served for 3 years in the Department of Justice in the tax division, and he clerked before that for Judge Katzman on the Second Circuit Court of Appeals and for Judge Orlovsky on the District Court for the District of New Jersey. Professor Gillian Metzger joins us from Columbia University. She teaches also in constitutional law and administrative law and is one of the co-editors of the influential Gellhorn and Buys administrative law casebook. She also, I believe, clerked for Judge Wald in the D.C. Circuit Court of Appeals and spent some time as an attorney in the democracy program at the Brennan Center at NYU. Professor Stuart Benjamin, we all know well here at Duke, is professor of law and associate dean for research here at Duke, clerked on the Ninth Circuit Court of Appeals and for Justice Souter on the Supreme Court, and spent time as attorney advisor in the Office of Legal Counsel in the United States Department of Justice. Professor Ernest Young is also a recent addition to the faculty here at Duke. I believe this is his first semester here. Welcome, Professor Young. Professor Young also clerked for Justice David Souter He is a member of the American Law Institute and was a much beloved professor, my friends tell me, at Texas before joining us here at Duke. So welcome, and we look forward to the comments. Professor Nina Mendelson joins us from Michigan. She also teaches in administrative law, environmental law, statutory interpretation, and the legislative process, and served for the Department of Justice's Environmental and Natural Resources Division before beginning her teaching year. Again, welcome to all of you. We're glad to have you here and look forward to a great discussion. Professors Galle and Seidenfeld, I think you will be starting us off. Welcome.
Thanks very much, Jonathan. Thanks especially to the Duke Law Journal for scheduling this event on a tax professor's favorite day of the year. It's my fault. And in particular, thanks to the Duke Law Journal for hosting this wonderful event and bringing us here. Thanks as well to Gillian for contributing her fantastic paper and to our other commenters for their tough but very thoughtful responses. We're really looking forward to talking to you about them. Some of you we know, especially our discussants, have read the paper very carefully. So I'm going to somewhat beg your indulgence during my portion of the presentation, because largely what I'm going to do is lay out more or less the basics of our argument, and then Mark is going to stand up and delve a little bit deeper. So our core claim is that federal agencies can sometimes, not always, but sometimes, be the best institution for determining the proper scope of federal power. Mark's going to follow me, as I said, and he's going to lay out in more detail why that's so. But I'm going to keep you in suspense for a while, because I'm first going to give you a little bit of the surrounding architecture, the doctrinal architecture in some part, for why we might care about which institution is the best one to figure out the scope of federal power. All right, so what's the doctrinal background? You've heard a little bit about it from Jonathan that makes us care about these issues. You all probably know there's a bunch of instances in which Congress, in theory, has the power to displace state authority, but in order to do it, it's got to do so with clear statutory language before a federal court is going to give effect to that supposed congressional enactment. For example, if you want to subject a state to a private suit, we know there are some substantive barriers to that, but there's also a sort of procedural barrier. You've got to do so through absolutely clear statutory language. The same is true in my field if you want to impose tax on a state instrumentality. And it's also true, although this point is a little bit more controversial, if you want to preempt a state law. And there's some murkiness in that doctrine, as we're happy to concede, and people can argue about what that doctrine means. But the general view is that there's a presumption against preemption, which has to be overcome by relative clarity in what Congress does. So these same rules apply to federal agencies, only more so. And it's the more so part that we really want to talk about. For example, an agency can't regulate in any one of these protected areas no matter how clear its own intent is, no matter how clear the agency's regulation is. It still cannot act unless it has itself been authorized clearly by Congress to act. So let me give you an example from the Supreme Court. The U.S. Army Corps of Engineers tried to regulate wetlands, even those that had no surface connection to navigable waters. And so the Supreme Court wanted to say that arguably the commerce power doesn't extend to federal regulation of purely local waters. So Congress, if it had chosen to, could have forced the court to confront that constitutional question by enacting a statute that clearly imposed restrictions on those waterways. There were some, such as the dissenters in this 2001 case, who thought that Congress actually had done that. The majority thought that they hadn't. And then they also said that the Army Corps, although its regulations were very clear about the requirements for local waters, couldn't regulate at all because there was no clear congressional authorization for them to do it. So once you've put your agency foot into this constitutional gray area, an area that's protected by federalism, you can't go there unless you have a note from Congress that says explicitly that you can. So similarly, Justice Stevens and some commentators have argued for extending the restrictions on preemption so that agency regulations would have preemptive effect only in the rare instance that they were expressly authorized by Congress to have preemptive effect and nowhere else. So for instance, since we don't see a statute that authorizes the FDA to preempt private tort suits, presumably there would be no FDA preemption of those private tort suits. So these sets of rules, this is where we get to the theoretical issue that I started with. These sets of rules have two implications for the ways in which the rules for federalism are crafted. So, two theoretical implications that come out of this requirement that we have clear congressional authorization before an agency can do anything. It forces, essentially, Congress to act rather than the agency. What does that mean? Well, first, as Professor Young and others have pointed out, one of the effects of these combinations of rules is to require that it's going to be very difficult to expand federal authority, right? It's a lot harder to enact legislation than it is to regulate. You've got bicameralism and presentment. You've got to get two bodies of Congress to agree, and we know they often can't agree, what time it is. That's actually true. There's a lot of dispute about daylight savings time. So on Ernie's account, and in the other similar stories that are told by other folks, Tom Merrill's one of the people that we single out in our paper as having made this argument repeatedly, this is not a bug, it's a feature. So they want to say that regulating is so much easier than legislating, that the consequence of allowing agencies to act rather than demanding that Congress step in is that federalism, whatever that may mean, I'll come to that in a second, federalism would disappear pretty quickly because there would just be mounds and mounds of federal regulation that would pile up because the barriers to creating it are so low. So let's talk about that for a bit, and then I'll come back to that other consequence of these doctrines that I talked about. Okay, so we're not about to dispute that. In fact, it's true. The barriers to regulation are lower than the barriers to legislation. That's hard to argue with. But we want to ask, is it always the case that more federal regulation is inconsistent with the goals of federalism? Right, so the claim is that federalism collapses under the weight of federal regulation. Is that always bad? And of course, that's going to depend on what we think of as the goals of federalism, a subject that I think we're going to have some disagreement about. And we see at least two main goals. And I think it's fair to say that we think that one of those goals is more important in the modern context than the other. So one of those goals is welfare maximization. Right? So if you have lots of policies all around the country, you've all heard these stories. You get more experimentation, people can live where they want, maximizing their preferences. The other theory of federalism that we suggest is a sort of a rights-protecting federalism. If you fragment the sovereign, it's easier to resist the sovereign. But what we want to say, and we can adopt someone like Immanuel Kant, is that if you want to protect state autonomy in whatever form, sometimes the maximal autonomy for all requires some constraints on individual autonomy. Right? So there may be some instances where you get more state autonomy by constraining states. And we say those are situations where more federal intervention, the greater ease of federal regulation means that you in fact have more state autonomy. And the easy story we think to tell here, the common story, is the race to the bottom story. Right? If states aren't able to achieve the policy objectives they want, because somebody else is pursuing a different policy that they have to compete with, right, then they've lost a measure of autonomy. Notice, though, that our claim is conditional. Right? So we're not saying that federal regulation is always going to be consistent with federalism values. We're simply saying that sometimes it better furthers federalism aims. So our position doctrinally is that the current rule that we see is wrong. The current rule that imposes an absolute bar on agency actions without any clear congressional authorization. But at the same time, we would throw out that rule, but we wouldn't say that there should be entirely unsupervised agency freedom to displace state authority. We'd instead say there should only be such agency license where it makes sense, basically. So we still see a very significant role for judges in supervising federal-state relations. But crucially for our story, we think that the increased participation by agencies is going to mean that when judges are being very active in enforcing federalism norms here, they're going to be doing it in a way that's more informed and more dynamic, because they're going to be able to piggyback on the work of agencies. That judicial role is also important for that second set of effects of the clear statement rules that I mentioned before, so let me come back to those. Again, a congressional clear statement rule, a rule that Congress has to authorize the agency to act, moves the burden of decision-making, basically, from the agency to Congress. Congress is a different institution than an executive agency. It has different institutional features. And traditionally, most commentators have argued that Congress's institutional pedigree is better than agencies in the areas that matter. Right? So Congress is said to be more accountable, is said to be more deliberative. And I guess the story here is that those virtues are even more important when the stakes are higher. So when we're dealing with measures of constitutional importance, we're talking about federalism and other perhaps individual rights, it's even more important that we be accountable and deliberative than in other occasions. That's the Cass-Sunstein story, for example. Now, Mark is going to say more about our take on, in fact, the comparative institutional competence, if you will, of these two organizations. But I'll just note for the moment, in keeping with my judicial role theme, that the institutional features of Congress and the executive are not wholly fixed. And I think one of our debates with Nina is going to be to what extent they are more or less fixed, and to what extent they're contingent on surrounding legal rules. Right? So Mark and I say that it may be that you're unhappy with the current institutional state of agencies relative to Congress, but that's not an inevitable outcome. And we think that it's possible to improve it. And I understand Professor Mendelson to be skeptical of that. So a significant part of our argument is devoted to suggesting that there could be rules of judicial review and also rules of statutory interpretation that could lead agencies to either rival or maybe even exceed Congress on those key measures that people are always talking about. Essentially, our claim is, why give up the advantages that the administrative state can sometimes give you, advantages which I won't bore you with now, if the downside that's said to come with those advantages can be cabined. Right? So you can get the good and not so much of the bad. What's to complain about? Again, this story is contingent. Right? It's not always going to be the case that agencies' weaknesses can be shored up. We concede that. So our claim is simply that the current set of rules, which again is a relatively absolute set, in which the ultimate federalism decision here is never the agencies, that set of rules is misguided. And instead, we should have a set of rules that's open to the possibility that sometimes agencies might get a better answer. All right, so recognizing, though, right, so far it sounds like we're trying to beat something with nothing, if you would. Right? We're saying the current theory is wrong, but we're not giving you any theory of our own. So we try to give you a little bit of a theory of our own, and we try to lay out some factors that for us are going to indicate when it is that a court should accept agency action and when it should be willing to do that, even absent clear congressional authorization. Although some indications of congressional intent short of clear authorization are going to matter for us. And so most of the factors, as you'd expect, again, I'm not going to bury you in detail, but they come from our analysis of those two effects I was just talking about. So, for example, if you are concerned that agency deliberation about rights protecting federalism is kind of shaky, and if you are convinced that that can't be improved by rules of judicial review, then maybe it's simply the case that your rules for deference to what an agency ultimately does should reject agency outcomes that bear on rights protecting federalism. Right? So if you're not convinced by our empirical claims, in some instances you just write a set of legal rules that covers for it. Where you're doubtful that agencies are competent, don't give agencies that much power. We have an additional factor that we throw in here is we think that courts need agency participation to make good decisions, essentially at all stages of their decision making. So we do think you're always going to have to give agencies at least a little bit of deference as a form of carrot to encourage them to at least begin the work of thinking about what the right rule is. Otherwise, courts will never have anything to rely on when they start to think about these issues. So again, I'm going to leave a lot of the hard work to Mark of talking about the comparative institutional competence, but hopefully this has at least framed for you our general argument and why it's important.
I won't repeat all the thank yous, but I'll just piggyback on Brian for all the thank yous and thank Brian for such a great introduction to my part. I will say that it's kind of a challenge. I've never done this before, where I've hardly ever co-authored, let alone co-spoken. And so I told Brian he could go first, being magnanimous, and now I'll try to fit in what I have to say, consistent with what Brian said, and point out any disagreements if I have any. Essentially, what we argue is that there are a lot of reasons why agencies might be more transparent in many situations, in terms of transparency in the sense of people not only knowing what they do, but knowing how the process works and how to get involved in and who to hold responsible for the process, might be more transparent, more deliberative, and more accountable than both the courts and Congress. And just to give you some idea of that, I'm not going to go into too much detail, but let's talk about deliberation and then maybe a little bit about accountability. I will admit, I have a very pessimistic view of Congress, in the sense that, from what I see, Congress is essentially, except for issues which perhaps create a broad, emotional kind of national debate, Congress, when I look at it, looks to me like a deal-making, trading kind of body. It is geared towards, not towards building consensus, but towards building coalitions. And a lot of times, I mean, you can say that that's, that you can tell a story where that's good, because by trading, just like in markets, and the pluralists sort of tell the story, by allowing trading in markets, you can let everybody be better off. If I trade a vote that isn't so important to my constituents for one that is, then my constituents are better off, and the other person is willing to trade, by the fact that they're willing to trade, their constituents are also better off, and you might think this is a good, and there are theories under which it can be. But if you believe the public choice accounts, that a lot of what Congress does is generating monopoly rents, that is, the government uses its power to give out benefits to focused interest groups at the expense of the broader public, then to some extent this deal-making and trading can just facilitate the generation of these rents. And so what we want to do is we would like a process, a political process, which would be more geared towards the flexibility to provide trades that make everybody better off, or consensus building, or win-win situations, versus just facilitating the generation of monopoly rents. And again, if you look at the congressional process, there really aren't public debates. There's no reason giving that's required of Congress. Occasionally the courts hint that they're going to require Congress to give reasons. I would venture that every time they do so, they retreat from that, because it doesn't work. Doctrines that depend on Congress giving reasons, generally Congress doesn't give reasons, and the court's left to kind of say, well, are we going to overturn everything Congress does because it doesn't give reasons? And so you don't really have, those doctrines have not been very effective. So you don't have reasons that are required of Congress, generally. And you don't know what goes on in the back rooms of Congress. You may know what the votes are, but it's hard to make sense of the votes. I mean, a lot of times the votes are strategic. You don't know whether there's vote trading. You don't know whether a vote is for something someone doesn't believe in to make the whole bill less palatable to the majority. There are all sorts of strategic behaviors that go on. So it's very difficult to sort of understand and see the congressional process, in my mind, as deliberative. Agencies, I think, are capable of being more deliberative. That doesn't mean that they are, but I think they're capable of it, probably for several reasons. One reason is, and this is sort of underlying the assumptions of the modern regulatory state, is that we will allow agencies the flexibility of combining functions that we would normally keep separate in our separation of powers notions of government, but we make them subservient to the various branches of government, so that they are both accountable, can be overridden, and are accountable to the various branches. And one aspect of that is that the agencies, in terms of congressional accountability, is the procedures that they are often required to use are such that they provide a mechanism for those who are affected by the agency action to know what's going on, to participate in what's going on, and perhaps more importantly in terms of oversight, to signal to Congress that, wait, the agency's doing something here that we don't like, which allows Congress to get involved not by passing legislation, which is very hard, but by seeking oversight hearings, by threatening to withhold appropriations, which is a form of legislation, but it has to happen. It's not, Congress can't not spend any money every year. And so it basically facilitates congressional action in a way that may be more flexible. And another important aspect of the administrative state is the fact that agencies generally under administrative law are required to give reasons for their decisions. And the courts have developed a doctrine that requires that the agency explain not only the general reasons, which was sort of back in 1946 when the APA was adopted, the Administrative Procedure Act, it was sort of you just sort of generally say what you're doing here, to the point where now courts say, well, we want you to look at the record that you have in front of you and explain to us why you chose the alternatives you did, that you considered all the relevant factors, which would be either explicit statutory factors, or I would contend in most cases there are some implicit factors such as efficiency, costs incurred, and other effects that are sort of presumed to be relevant unless Congress takes them off the table. And so you have the agencies that are geared in some sense towards this deliberative notion. I would even go so far, and this is an interesting point. I don't know if it's been said before, but I would say that agencies in some sense are more accountable than Congress, and this I think surprises most people. You'd say, well, Congress is elected and agency officials are not elected. We know that they're subject to being overturned, they're subject to embarrassment at hearings, but that's not the same sense of accountability. And you can talk about the lack of transparency in Congress and the problem with when people vote for people in Congress, they may not know exactly what that person's position is, but there are ways around that with interest group signaling and things like that. But here's a very simple way in which I think agencies are more accountable. It is the very inertia of Congress that Ernie relies on in terms of discouraging action that means that Congress isn't as accountable in the sense that it has to, by necessity of its procedures, act episodically. That is, when it passes a law at one time, it is unlikely, unless all hell breaks loose and everyone says you've got to do something, it is unlikely to revisit that law for some time and maybe for a very long time directly, because it's hard to pass legislation. It has a limited, it has a general jurisdictional grant over all legislation, limited time, limited resources. And so what happens is that Congress passes these laws, but in order to really keep the laws current with the changing times, it can't revisit the law, so it oftentimes delegates to an agency over whom it has some influence, and the agency can act much more continually in terms of determining how the law operates. And in that way, if the agency is subject, maybe not as directly, but is subject to the influences of politics, because the inertia is lower and it doesn't act episodically, it may actually be more responsive to politics overall than the legislature itself. In a funny way, I guess what I'm saying is, the legislature, when it acts, the legislature may be more responsive, but the barrier you have to overcome to get the legislature to act may be so high that overall you still get more, even though it's imperfect, you get more responsiveness overall by having the agency act because the barriers to action are lower. And so you can do it on a more continual basis. So that's the basic sort of reasons for preferring agencies to Congress. And with respect to courts, I suppose courts are deliberative. We didn't go into it in detail, but you can talk about, they're obviously of limited accountability in terms of reflecting the preferences of the current polity. They're not unaccountable, but there can be a big lag between preferences and where the judiciary ends up. Okay, so that's why, in some sense, we say that agencies can be more deliberative and more accountable. how does this play out with respect to, well, let's talk a little bit more about the generalities and then talk about federalism and in particular preemption, which is the part that I sort of focused on. Well, you can criticize agencies and say, well, agencies have a tendency to want to maximize their reach or power, and therefore, by making action easier, we have to worry about that. And I'm not going to dismiss that totally. Certainly, that is a factor. Although, if you look at the empirical evidence, and it's not very analytic, it's not good econometric kind of data, but if you look at the studies of these agencies, at least at the staff level, and usually the staff doesn't see themselves as an aggrandizing sort of entity. They don't see themselves as saying, oh, I want to get more power for the agency. They're pretty professional. They pretty much see their job in terms of their professional norms and doing their, being good at what they do. So, again, I don't have great evidence on that, but that's what these sort of surveys seem to suggest consistently. Agency heads as well, you'd think, well, they have an incentive to maximize the power in their agencies, but again, it's kind of controversial, but it turns out that it looks more like they're much more concerned about avoiding oversight than they are about actually getting more and more power. At some level, it depends on the nature of the agency and the agency head, but to some extent they have their reputations, and they may want to go on from the agency, and so they just don't want the oversight, they don't want the negative press and things like that. And more importantly, as Brian alluded to, and I'll mention here, the agencies are subject to checks because we have, if they do aggrandize their power or act in a way that people are upset with, then they do, if Congress is upset with them, they get called in before the congressional committees to hearings, and we've seen how that works with the Department of Justice recently, and it can have some pretty interesting ramifications for the agency head. I read the story that Alberto Gonzalez is unable to find a job in a law firm right now because people are not interested in hiring him, although he's doing okay on the speaking circuit, I'm told. So that's an interesting, real-world example of the effect of what oversight can be. So, there are checks, and I'm not sure that I make too much of that critique. There's also a critique of agencies discounting experimentation. I guess the argument is they think their answer is best. And again, here I don't want to get into too much detail, but it really turns out to be important as to when the participants are able to, when the interest groups are able to participate in the agency process. The earlier, the better, because agencies arguably can become wedded to their positions. But they have a strong incentive not to be too wedded to their position because, because of judicial review, they can't be wedded to the position to the point of ignoring the record. And a lot of times, even though you've heard, those of you who've taken administrative law heard about notice and comment rulemaking, most of the action occurs and the interest groups get involved before the notice and comment period opens, when the agency rulemaking team gets together. The environmentalists will have, an environmental agency will have their constituency. The industry will have sort of the policy analysts and the economists involved, and so they're sort of represented through the staff in oftentimes in very early stages. And again, like I said, if you ignore the evidence, at least from the staff level, they are concerned about that because then the courts tend to make judicial review difficult or be more apt to reverse the agency at judicial review. And there are some people who claim that is something that scares agencies so much that they actually take comments and input too seriously. Okay. So that leaves us with this notion that the agencies are at least a plausible alternative, perhaps a superior alternative in many instances to Congress and the courts for making determinations about, at least from a welfare perspective or a public preference perspective, about what the bounds of these federalism issues should be. when we apply this notion to one of the principles of federalism, at least, let's talk about preemption. Where do we come out? And we lay out a set of criteria that we think drives how courts should make determinations of agency determinations that their rules should preempt, that is, displace state regulation. The first thing is that Ernie has developed his notion of resistance norms to protect federalism. I want to develop a notion of an assistance norm. And that is, I think that because of the advantages, not of necessarily deferring to the agency, but involving the agency so we can get more expertise, more openness, more discourse out of the process, I think that courts, and Brian may not go as far as me in this, but we both agree that a resistance norm is inappropriate, that we shouldn't discourage the agency from being involved. I would go so far as to say that I would think that the courts should read statutes to permit and facilitate agencies to address the federalism question unless Congress has fairly clearly indicated that it doesn't want the agency to do so. In other words, if there are benefits to doing this, I'm not giving up congressional superiority and saying we don't care what Congress said any more than Ernie is when he uses his resistance norms. But I am saying that because if welfare would be increased by involving agencies, then I would say that there's a good reason to read statutes to involve the agencies unless Congress has said, no, we've made the determination and we don't want that, in which case Congress obviously takes priority. And within that, so the first step would be don't disable the agency from acting. The second step is the harder step, which is we want the courts to consider this in a way that encourages the agencies, if they're capable of being more transparent, deliberative, and accountable, we want to make sure that they are. And so we have a set of criteria there that I think help guarantee this. And the first criteria is that we want the agency to give reasons for its decision, reasons that aren't that are uniquely within the agency's capacity. For the sake of time, I know that I'm going over a little, but Gillian told me that she's going to give up some of her time to me if I wanted it. She didn't quite say it that way, but I got the message. But to not go over too far, we're not talking here about the agency saying, we read the statute as intending either to mandate preemption or to prohibit preemption just on a semantic reading of the statute. I don't see the agency as having any real advantage there, except perhaps of the fact that it doesn't have to act so episodically and maybe being more in touch with the values of the polity. But even then, it should give some explanation as to why that's true. So we would want some agency reasons that deal with both the agency's technical expertise, its greater accountability, its consideration of the issues that, and if the agency can't give these kinds of reasons, the kind of reasons courts have demanded explicitly outside of the federalism context for general agency decision-making, we think the court should demand that for federalism issues. That is, not only what did you do, agency, but why did you decide that it was appropriate or best, I shouldn't say appropriate, but best to disable the states from acting in this circumstance? Why aren't the benefits of experimentation outweighed why are they outweighed by the notion that your answer, that you need an answer now and you need a unified, centralized answer that isn't going to allow such experimentation? What are the benefits of doing it that way? What are the costs of doing it that way? We also think that, and that's probably the most important factor, but there are other factors as well that the courts might look at. The structure of the issue. Is this a matter where either the state or federal institutions have an incentive to act contrary to the public interest? Are the states engaging in cost exporting in such a way that the agencies say this is not in the public interest? And you would know more about that if the agency gave reasons, I would think. But is that a plausible explanation of what's going on here? Or is this a situation perhaps where the agency's shifting blame? I mean, one of the things agencies might like to do is to say, we're going to make a controversial decision because we read the statute as saying Congress left us no choice. To me, that's a great blame-shifting mechanism. The agency is many times being either on its own or being told by the president to say, I don't want you to do this, but don't blame me. Put the onus on Congress and the statute. So it's just a blame-shifting kind of situation. Also, is this an administrative matter that's going to have external costs to the agency itself? I mean, the example of an agency interpreting a statute that might get into the gray area of what's constitutional or not, thereby forcing the court to determine whether it's constitutional or not, might or might not be appropriate for the agency depending on what kind of constitutional issue it is. So in Rust v. Sullivan, the kind of issue that came up, whether the First Amendment and the issue of whether the government, by spending, is allowed to to have preferences, and how do you draw the line about the preferences the government can have that are content-based preferences, goes way beyond the notion of family planning clinics that are advising their clients about abortion and things that the government did, that the administration at the time didn't like. It goes to a whole host of circumstances, and if the court had come down and decided that issue, the decision could constrain Congress in the future, other agencies in the future. I mean, it had ramifications way beyond what this agency did, and the agency would not necessarily take into account those ramifications. They might say, well, if we lose, we lose. It's not a big deal. Let's present it to the court. Well, that's the kind of thing where the agency would be, I think, you'd be suspect about saying to the agency, we would give deference to the agency because they're really not taking into account the full implications of their decisions. The Swank case, I think, is very different. I don't see, maybe I'm not imaginative enough, but I don't see what the real export of the notion of what are the waters of the United States when we're talking about waters that are hydrologically isolated. I mean, we're not talking about shipping, we're not talking about commerce in the usual sense. The only implications are, to me, are the extent of environmental statutes, and I don't see how this is going to constrain either Congress or the agency beyond the very meaning. Plus, in that case, the third factor I'd give is, which relates to that, is did Congress give any indication, even if it's not clear, that they want the agency to be able to go this far or the statute to be read this far? And again, in the Swank case, Congress said, we define the waters of the United States to be, to go as far as the, I don't know the exact language, but to go as far as the Constitution seems to permit, or at least allow the agency to do that. So I'm not much less troubled by allowing the agency in the Swank case to address the issue than I would be in the Rust v. Sullivan kind of case, because of these things. And finally, the procedure. What procedure did the agency utilize? This is important, again, because of oversight. One is transparency and participation and deliberation. Obviously, notice and comment proceedings are more open than sort of behind-the-scenes interpretive rules that the agency might issue without them, but also for accountability. And here I'm relying on the sort of the work of McCubbins, Knoll, and Weingast, and this fire alarm system. That procedures matter because they can stack the deck towards a constituency that Congress wants to give an advantage to in the regulatory scheme, and can also allow that constituency to inform Congress when things are going awry before they go awry. And so a lot of times, we'll see, do agencies get things wrong? Yeah, they get them wrong. But sometimes when they get them wrong, or a lot of times, Congress is going to call the head of the agency in front of it and rake them over the coals. And that's easier than passing statutes, but when we see that, we might say, well, that's the system working, not the system not working, because in some sense, if the agency gets it wrong, that's the price they pay, and we see whether that corrects itself or not. I don't want to go on further, but those are the kinds of factors that we would use in determining the level of deference. So just to summarize, because of the potential for agencies being superior to Congress and the courts, I would say that that we should have an assistance rule that says we want to facilitate the agencies being able to to address these questions, but at the same time, once the agency addresses it, the level of deference that is to be given will vary with these factors, the reasons factors, the motivation factor, the externalization factor, and signals from Congress. It's pretty much all we have to say.
Thanks. I'm delighted to be here. And I did indeed say that I can't imagine myself talking for 45 minutes. So Mark's welcome to the time. I also hope we'll have more time for the fireworks, hopefully, with the response. My paper, like Brian and Mark's, is on the relationship between administrative law and federalism. That's now a hot topic, as we've heard. Who'd have thunk it? And there is this very interesting political drama and drama at the Supreme Court all about administrative preemption. And you've got the Bush administration, trying to preempt tort suits out of existence and so forth. I wish I could say it was something as interesting and politically charged as that got me interested in the relationship of federalism and administrative law. But I have to confess to being a bit of a law academic geek, and it was actually the footnotes in the Raich opinion that got me interested in the relationship between federalism and law. Raich is the case, the medical marijuana case arising under the Controlled Substances Act, and there, in the course of holding that Congress did have power to prohibit personal medical use of marijuana, the court repeatedly in these footnotes emphasizes the option of administratively petitioning to have marijuana relisted. So it's within Congress's power, but did you consider administratively trying to get the current rules changed? And so I was interested in why the court was doing that, and then subsequently we had Gonzalez versus Oregon, the Controlled Substances Act Part 2, where the Attorney General tried to prohibit doctors from prescribing drugs to assist in suicide. And again, the court relied there much more directly, in fact, it really is relying on administrative law over direct use of federalism to rebuff that effort by the Attorney General. So all this got me interested in the relationship of federalism and administrative law. And I mention that because the origins of the paper actually mean I take a bit of a different analytic stance than Brian and Mark do. I'm also very interested in the questions of comparative institutional competency that they analyze so well. And my ultimate prescriptive normative conclusion is quite similar. I also think that administrative law can be a very effective mechanism for protecting state regulatory autonomy. And I also think that courts should try and develop that federalism reinforcing potential of administrative law. But the paper also has this substantial descriptive and positive component, where I analyze how federalism and administrative law are being currently linked in the court's recent jurisprudence. In addition to Raich and Gonzalez, I talk about, in Oregon, I talk about the Alaska Department of Environmental Conservation case, or ADEC, Massachusetts versus EPA, the greenhouse gas case, Waters versus Wachovia Bank on banking, and the more recent Riegel case on preemption in regard to the Medical Devices Act. And these are all high-profile, generally quite contentious decisions. And what I find interesting about them is that they all present instances where administrative law and federalism intersect. And so I focus a lot on those. I focus on those not only because I'm curious about how the court is approaching this question, but also because how the court is approaching the question, for me, matters a lot about where we should try to go with doctrinal suggestions and scholarship in terms of addressing the relationship between federalism and administrative law. So let me begin by laying out some of the descriptive component and then hit on some of the more prescriptive and theoretical themes. In the descriptive part, what I see going on in these decisions is that federalism concerns, and I'm particularly interested when I say federalism concerns with the question of preserving a meaningful regulatory role for the states. Call it state regulatory autonomy or what you will, but that's the aspect of federalism that I'm focused on. And what I see going on in these decisions is that state regulatory autonomy and federalism is being advanced through application of an administrative law framework. That's not to say the states emerge victorious. They actually, if you look at the win-loss record, it's not so great. But my point is more one about the court's overall analysis rather than the ultimate results. A second caveat, in addition to you can't focus necessarily on the bottom line results, and this second caveat may be more important, it's not clear how conscious or intentional the court is in using administrative law in this way. Only in the Massachusetts versus EPA cases the court really expressly linked federalism and administrative law. Instead, what I see in the cases that I think is interesting is, first of all, a lot of surfacing of ordinary administrative law, kind of basic doctrines that will get drilled into your head if you ever take administrative law, about invocation of reasoned decision-making, procedural requirements, statutory interpretation frameworks. And these come up repeatedly in the decisions, and they come up repeatedly in ways that suggest potential that either actually redound to the benefit of the states or potentially could redound to the benefit of the states. So we see a lot of surfacing of ordinary administrative law. There are also some instances, and these I think go more to the thought that maybe the court is intentionally doing something here, where you see the court applying a more searching scrutiny than it usually would. These are largely in terms of statutory interpretation in Massachusetts or Oregon, but you also see it coming up in terms of suggestions about reasoned decision-making, a little bit in ADIC and in the suggestions in RACH. And this unusually searching scrutiny, which, although it's unusually searching, I think still falls probably within the ambit of administrative law, because another thing you'll learn about administrative law, if you take administrative law, is that it has a very wide spectrum within it. But so I see what the court is doing is beginning to address these federalism concerns through administrative law, and we see the surfacing of administrative law in these ways. The other thing that's interesting about these decisions, I think, is what's not in them. And there are two things in particular that are not present. The first is there really isn't any real effort by the court to impose direct constitutional curbs on the scope of congressional regulatory authority. RACH is the clearest example of that in the form of the court's acceptance of the broad scope of the commerce power. In many of the other decisions, I think the court is fairly dismissive to the extent it even considers at all the claim that the regulation at issue might be outside of Congress's power. This phenomenon of the court's unwillingness to cut back on Congress's regulatory authority is not limited to these decisions. It also undergirds another central line of precedent, central in particular to the questions of administrative preemption, but to the relationship of federalism and administrative law more generally. And that is the court's rejection of efforts to clamp back on Congress's ability to delegate broadly to administrative agencies, which the court has never actually, other than a couple of decisions in the 1930s, but has never really been willing to enforce non-delegation doctrine with any significant bite, and most recently in its Whitman decision, reject the most recent effort to get it to. So we've got one thing we don't see is any real effort to impose restrictions on Congress's regulatory power in these decisions. And in general, Congress has very broad regulatory authority. That's not to say there aren't any curbs. You do have the court still enforcing state sovereign immunity limits with some vigor. There's also federalism curbs in terms of the commandeering doctrine. And we still have, obviously, the Section 5 jurisprudence of recent years that had gotten more rigorous. But none of those, I think, really impose significant curbs on Congress's regulatory authority. And I think these decisions reflect the fact that the court's not really interested in doing that. The second point is not only is this kind of direct constitutional federalism absent, so too, I think, largely is what I call subconstitutional federalism. It's also called quasi-constitutional federalism by some, or process federalism. And these are clear statement rules, other doctrinal mechanisms, presumption against preemption is one, all of which are geared towards ensuring that Congress adequately considers and clearly authorizes intrusions on the states. And here I think the Oregon case is particularly striking because there the court expressly disclaims the need to turn to these sub-constitutional, quasi-constitutional doctrines and instead invokes what it calls the familiar principles of administrative law, and as a result of doing so ends up protecting the state. Here I think I may differ a little from Brian and Mark. I don't think that we see sub-constitutionalism clear statement rules surfacing that much or that consistently in the preemption decisions either. They certainly do exist in terms of spending conditions. They do exist in terms of waivers of sovereign immunity. But one of the interesting phenomena of late has been a growth in very freewheeling preemption analysis at the court, where the court is much more willing to find preemption despite the lack of a direct conflict. We saw that case in point in the Waters decision. So I'm not sure how alive these subconstitutional federalism doctrines are when you're talking about actions, when the court is reading congressional determinations, even when you don't have an administrative agency around. But I think it's interesting in these cases where you do have this intersection of federalism and administrative law, when you would think subconstitutional federalism should have some bite. This is, after all, subconstitutional federalism is a doctrine about how do you deal with instances of concurrent federal and state authority and make sure that the state authority continues to be meaningful. I think it's interesting that it isn't the framing that we see in these decisions. So what to make of that? Well, one thing to make of that is that, guess what, the court isn't actually that concerned about the states after all. I think there may be some truth to that in some instances. Its bottom line sympathy for the states may be somewhat limited. I don't find that answer fully persuasive, though, because I think although the court's sympathy for state interests is limited, I think it's actually real. I think that the court really is genuinely concerned with the implications for the states. Or to put it differently, what I think claiming that what's going on here is that the court doesn't care that much about the state ignores is that the court does care about the states, but is trying to get at that through administrative law. What I argue in the paper is it shouldn't be necessarily so surprising that the court is choosing administrative law rather than more direct, straightforward federalism doctrines as a way of advancing state interests. And the reason why I don't think it's surprising is that I think these kinds of subconstitutional federalism doctrines, clear statement requirements, don't fit so well with administrative contexts. Because when Congress has delegated authority broadly, you do have a statement from Congress. And in general, the traditional way the court views that kind of delegation is quite broadly. So demanding clear specification, demanding that Congress speak to specific issues is at odds with how the court generally treats delegations. And the net effect, going back to something Brian and Mark did mention, is to create exactly the kinds of obstacles to congressional action that the court, through its reluctance to put constitutional curbs directly on Congress, seems unwilling to do. So it's not to me surprising that we don't see those doctrines coming up in this context. And I think using administrative law allows the court to bypass some of those problems, some of those obstacles, because it can work within the delegation and can also target, for example, particular decisions rather than authority more wholesale as a way of targeting particular decisions that might seem egregious or particularly unsympathetic to the states, but without really having to take on the challenge to the modern national administrative state. So that's the background, the descriptive background. And that forms the basis both for my theoretical and prescriptive arguments as well, because accepting that the court is using administrative law this way, and some might very well challenge that interpretation of these cases, but for the moment, just accepting that, that sets up two questions. One, is it constitutionally legitimate for the court to do that? And then two, the issue that we have heard more discussion of, how well does administrative law serve this federalism reinforcing role? In the paper, I don't offer that extensive a defense of why, on the constitutional question of why federalism concerns with preserving a meaningful role for the states are relevant, notwithstanding the fact that the court is not going to impose direct constitutional curbs on Congress. One could say, if it's within Congress's power, then it's within Congress's power, and federalism should just drop out. I'm not persuaded by that, and I largely get to piggyback in the paper on work that Ernie and others have done, who have talked about how important it is to make federalism real in instances of concurrent authority. And in terms of analytic justification, to me, the most important point there is that federalism is not simply about specific grants of authority. It's a basic structural principle of the Constitution. It's one of those structures and relationships that Charles Black famously referred to. And therefore, it's not enough to simply say this is within Congress's power in specific instances. There does have to be attention paid to the overall relationship between federal and state governments and what it means to give the states continuing vitality as independent or quasi-independent sovereigns. The other reason why I don't put much effort into justifying that proposition directly, other than, by the way, the paper would then be, double, is that the court is concerned about federalism. It's not the case that because it's not willing to impose constitutional curbs directly, that the court has given up on federalism. As I said before, I see the court actually still remaining concerned and trying to give some way of protecting the states. And moreover, this use of constitutional values in the institutes, right, is actually a very common phenomenon in jurisprudence and in many forms of statutory interpretation and in the court's approach on many fronts. So it's not unusual for the court to do generally, and it's also not unusual in the context of federalism to some degree. And so those two reasons are why I don't give that much to why we should be defending use of federalism in administrative law. I think the more interesting question, though, is the comparative one of, okay, suppose we buy that it's justified to try and defend a regulatory role for the states, notwithstanding we're not going to impose direct curbs on Congress. How should we do that? And in other words, comparing the administrative law approach with the quasi-constitutional or sub-constitutional approaches that focus more on clear statement roles. And here, I think the administrative law approach does well because I think it avoids some of the criticisms that are lobbied against clear statement approaches for unjustifiably constraining Congress. I'm happy to go on that later, but I expect that's going to come up in the response, so I'm just going to leave the issue of legitimacy there. On the question of comparative advantages, the second issue, so okay, assuming it's legitimate, how good is administrative law at protecting state interests? I actually end up agreeing with a fair amount of Brian and Mark's analysis of agencies and other institutions. So rather than repeating their arguments, I thought there would be a few points that it would be more useful for me just to emphasize. One is that although the comparative institutional analysis is useful, as they also underscored, I think, the key issue is also institutional combinations, right? How do you harness the federalism potential of all the institutions involved rather than necessarily picking the one that might be more effective on its own? And this is, I think, one of the main advantages of the administrative law approach, because administrative law is all about how do you combine deference to agencies with sufficient independent judicial scrutiny to ensure adherence to congressional direction, to guard against agency action, and so forth. I talk about this in the paper as administrative law's capaciousness. It's institutionally capacious in that it spans not only agencies but also how courts and agencies interact. It also connects to Congress. Administrative law is also, though, doctrinally capacious. And as I mentioned before, within ordinary administrative law, you have a broad range of approaches that allows courts, I think, to scrutinize agency action more carefully and defer less when they're suspicious that what is afoot is administrative overreaching, and defer more when they think they've got a well-reasoned, well-explained, carefully deliberated agency decision. So what I think that means is that under using administrative law and under an administrative law approach, courts retain adequate room to check any agency abuses, which no doubt will occur because they occur in other contexts as well. The point is not that agencies are perfect, it's that courts are available to check them through the traditional administrative law rubrics. And then there's also the important incentivizing aspect that Brian and Mark also mentioned, which is that administrative law not only can check agency abuses, but through the synergy of courts reviewing agency action and agencies anticipating judicial review, courts can actually also incentivize agencies to take state interests seriously. The second point that I want to make is that I think the relevant institutional comparison is really between courts and agencies and less between Congress and agencies. This is not because Congress is irrelevant. I think Mark alluded to, no one disputes that agencies can't act absent a congressional grant of authority. But again, we have congressional grants of authority. And the reason for focusing on courts and agency rather than Congress versus agencies is, again, the court's disinclination to seriously curb Congress's power to delegate. It is not, the court has shown no signs of being interested in making Congress make specific decisions on regulatory matters. And it's not interested in doing that for the reasons indicated about the effect that would have on Congress's regulatory power and the kinds of hurdles that would create to exercises of federal regulatory authority. And so I don't see the court being interested in imposing that burden on Congress. And therefore, more interesting is to think about, okay, Congress is going to be delegating broadly, which are the two institutions that we are then left with, courts or agencies, and as I indicated before, what combination of those institutions could be most effective here. The court's reluctance to substantially curtail the national administrative state leads to, I think, another advantage of administrative law. And that is that I think the courts are going to be more willing to impose administrative law, and this is what I see, more willing to address federalism through administrative law. And this is what I see in the decisions that I talk about, precisely because it is not, it is a generic doctrine. It is not thought of as a primarily constitutional doctrine. It is one that is thought to be subject to constitutional change. It allows courts to target agencies rather than Congress. And as a result, courts are more willing, I think, to impose federalism as a concern when they do it through administrative law than they are if they have to take a more direct federalism approach. I call this the normalizing function of administrative law, but I think it is also an important part of making federalism relevant today. Part of why courts are more willing, I think, to address federalism through administrative law, by the way, is because federalism loses its trumping power. So part of the deal is it becomes a consideration that will be enforced and that becomes more part of the everyday concerns of government, but it also loses the trumping capacity that constitutional or quasi-constitutional federalism doctrines would have. Okay. My final comments is that even though I think administrative law has this great federalism potential, or potentially has this federalism potential, that's not to say that I think that administrative law is currently being very effective as a surrogate for federalism. I do see some signs for optimism in these cases, but there are also some major deficiencies. And I talk about these at the end of the paper, I think it's interesting to think of how using ordinary administrative law, so for example, greater enforcement of standard procedural requirements, use, as Brian and Mark have talked about, of hard look scrutiny, could enhance the attention that agencies pay to federalism. But actually the greatest deficiency I see in these decisions is the fact that the court hasn't expressly linked federalism and administrative law and given some indication of how it sees that relationship, and therefore signaled to agencies and to lower courts that that's a relationship that needs to be developed. And I think that if administrative law is going to yield any significant benefits here, it can't just be tacit. There needs to be more express discussion of how administrative law and federalism can and need to interact. Thanks very much.
Folks, we have three wonderful responses to these presentations. I think we'll take just a brief 5-minute break so we can grab some refreshments out in the hall, and we'll convene back at just before 5:30. Thanks.
Okay, thank you. I want to say a particular thanks to the Duke Law Journal for inviting me to participate in this symposium, and it's a great pleasure to be on this panel with such thoughtful colleagues. I guess I want to make a couple of comments, primarily in response to Professors Galle and Seidenfeld. The backdrop again here is a situation where we have some congressional authorization to agencies to act. No kind of free-floating authority in the agencies, but very often these statutes that give agencies authority to act are very broad. So the FDA has rulemaking authority as necessary to carry out the provisions of this chapter. EPA has similar rulemaking authority. It's a very broad delegation, and as I think Professor Metzger correctly observed, the court is very willing to let agencies act, often in very many ways that they see fit, to implement their statutory programs without requiring Congress to supply a lot more detail in terms of their statutory instruction. So the question is, how far are we going to let agencies go when the question is preempting state law? So perhaps they can go fairly far in figuring out the details of how to improve auto safety or how to protect the public health. But can the FDA say, pharmaceutical manufacturers, you don't have to put anything more on your label than what we say, even if, under state tort law, you would be required to do so? Can the FDA say to the state of California, we don't think pregnant women should eat too much tuna fish because of the mercury, but we don't want you to require the tuna fish manufacturers to actually put that on the label of the tuna fish cans. So that's really the question at issue here. How far does this normally quite broad agency authority to implement their programs going to go? Should it go as far as preempting state law? So why spend so much time talking about functional concerns? Because I think that is where Professor Galle and Seidenfeld focus us, and I think that's quite appropriate. The other backdrop here, I think, is the Chevron doctrine. As part of Congress's delegation of authority to agencies quite broadly to take action to implement their programs, as those of you who have taken administrative law know, the court has reasoned there's also an implicit delegation of interpretive authority to agencies. So if a statute is unclear, the Supreme Court has said an agency's reasonable interpretation ought to be upheld. Why is this? This is because an agency often offers advantages in terms of institutional competence over courts in figuring out how best a statute should be interpreted so that it works properly, and because an agency can also offer advantages in terms of political accountability. So I think it's completely appropriate to frame the discussion in terms of these questions of expertise and political accountability. So Professors Galle and Seidenfeld, I think, give us a really important strand, a really important addition to the discussion about preemption when it's done by administrative agencies. Right? It is quite possible, as Galle and Seidenfeld argue, that maybe state interests are going to receive a more accountable hearing in the agencies, right? A better reasoned hearing in the agencies that agencies have by virtue of their procedures, such as the notice and comment process. They have procedures that perhaps are going to give them incentives to listen to state interests and to think about them as they reach their decisions. And perhaps those procedures are at least as good as whatever the states can get in Congress. And that's the argument, roughly speaking. And this goes to the part of the analysis that has to do with the incentives of an institution to listen to particular arguments about whether state law should be preserved. And I think all of the presenters today would want to say that agencies should face even further incentives to reason more carefully about state interests in deciding whether or not state law should be preempted. Perhaps that is by some kind of enhancement of judicial review. So I want to make 3 points in response to Galle and Seidenfeld. One is I think there is a striking agreement among most of the commentators in this area. And I think it's worth thinking about why that is. The second point I want to make is that I think Galle and Seidenfeld have underplayed some of the problems agencies face. That even though agencies might have good procedures, even though agencies might have incentives to listen to state interests, they're not listening to state interests. And I think that largely has to do with reasons of institutional competence. And the third point I want to make is I think the answer to this is not enhanced judicial review, but like Professors Young and Benjamin, I'd like to see additional congressional action. Okay, so the first point here is I think there's a striking agreement here. Those of us on the panel have definitely are doing some writing on preemption, but there are others involved as well. Professors Galle and Seidenfeld, Professor Metzger, Professor Sharkey at NYU, Professor Merrill at Columbia, and myself either have articles in print or in draft that are about to be published that roughly all agree that on a couple of fronts. We roughly all agree that we have something to learn from agencies, that a lot of the questions about preemption of state law are practical. So, for example, how hard is it for auto manufacturers to comply with multiple state standards? That's something that an agency that has expertise in regulating auto manufacturers is likely to be able to tell us, right? And so courts can learn something from agencies. So we shouldn't say agencies should be completely out of the preemption business. The other area in which we all agree, however, nobody's willing to let agencies end the discussion on preemption, right? Nobody is advocating, for example, Chevron deference on preemption. All of us are saying it should be something along the lines of Skidmore deference, which is a kind of judicial review of agency actions where courts evaluate the agency analysis by, roughly speaking, how persuasive it is. And that means paying some attention to the parts of the agency analysis that courts think are valuable, but not having agencies dictate the outcome simply because you might call their interpretation of the statute reasonable. So I think it's a striking level of agreement. Nobody's willing to give away the store to agencies. Right? We all think there's something to learn. Perhaps we all adhere to what Professor Metzger calls the assistance norm. Agencies can give us some assistance, right? Or I'm sorry, Professor Seidenfeld. Agencies can give us some assistance, but nobody's willing to let agencies end the discussion on state law preemption. The second point I want to make is I think there are even stronger reasons than Professor Galle and Seidenfeld acknowledge for saying we should not give away the store to agencies, that unless we have clear statutory guidance from Congress, agencies should not be able to preempt state law, and judges should not be deferring to agency interpretations of preemptive provisions. So, in the papers, both Professor Metzger and Professor Galle and Seidenfeld talk about the kinds of expertise that are needed to answer a question of whether federal law should preempt state law. One of the questions is, of course, what does the statute say? And how should we understand it with reference to the concerns that motivate the preemption doctrine? How hard is it for multiple regulated entities to comply with multiple standards? What's the value of having states in a policy arena experimenting with new regulatory approaches? How important is it to have multiple regulatory approaches if, for example, regulatory issues vary from region to region? One of the areas in which this has come up recently, it turns out that the Southwest is dealing with a problem of lead-contaminated Mexican candies. I don't know if people are familiar with this, but there are spicy Mexican candies that are coming into California and Arizona and New Mexico. The FDA has a food safety program, but it's not regulating it because guess what? In Michigan, nobody eats these candies. This is primarily a Southwestern problem. And so the agency has elected to allocate its resources to national problems. That's an example where you might say it's really important for states to be able to retain some local authority to deal with these distinctively local problems. Right? So that's a value of having states active in the regulatory arena. And then there's this issue, of course, of having states experiment on regulatory policy, perhaps provide a different option to the one the federal government has chosen. So I certainly agree with Professor Seidenfeld and Galle that agencies can offer a lot on a number of aspects of this problem. Agencies can have a lot to say about compliance issues. Agencies can have a lot to say about local variance issues. Where I think we part company is in the most abstract of the federalism values, which is the extent to which states serve as a laboratory of experimentation, in the words of Justice Brandeis, or where states serve as counterbalance to federal authority. Now, all of these issues do arise often in the context of a very concrete problem. Should the federal Food, Drug, and Cosmetic Act preempt state tort claims that come out of pharmaceutical labels? But they're all distinct issues. And I think that these are issues that, for whatever reason, the agencies seem to be showing themselves very ill-suited to analyze. So let me give you a recent example. At the very end of February, EPA issued an opinion supporting a decision that it made to deny a waiver of preemption to the state of California to regulate greenhouse gases in automobiles. How many of you all are familiar with this, the greenhouse gas waiver for cars? Okay, so a few of you. It's gotten some attention in the press lately. The Clean Air Act makes the authority to regulate car pollution, automotive pollution, exclusively federal. Okay, so states are preempted, with one exception. There is a waiver of preemption for California. Since 1967, California has been allowed to ask for special permission to regulate, set its own standards for cars, and EPA has the authority to grant or deny the waiver. So the statute provides the circumstances. As you may know, California is a pioneer in regulating auto emissions. So California regulation is one of the reasons why we now have catalytic converters on cars nationwide. California regulations is what prompted the development of the hybrid engine by auto manufacturers. So in 2004, California issued its first ever greenhouse gas standards for cars, which would have resulted in a 23% reduction in greenhouse gas emissions from new cars by 2012 and a 30% reduction in global warming emissions for new cars by 2016. So pretty significant reductions in greenhouse gas emissions. So why spend time talking about this? I think this is a great test case for Professors Galle and Seidenfeld, which is why I think I want to spend some time on it. The statute says that EPA is supposed to grant a waiver of preemption, let California set its own standards, unless California cannot show that there are compelling and extraordinary circumstances that justify regulating. So it's a statutory standard. But it's a statutory standard that bears on the extent to which state law is going to be preempted. And what EPA reasoned, the question facing EPA was, did the compelling circumstances have to be local? Did it have to be a local air pollution problem that California was trying to solve? And what they ended up concluding was that it did have to be a local problem, but that California had not succeeded in showing that there was a local problem for them to regulate, because the warming problems that they were facing were, of course, from greenhouse gas emissions worldwide. Okay, so this is an interpretive question about the breadth of a statutory preemption provision. And I think it's a great test case for Professors Galle and Seidenfeld because of the procedures with which the agency had to comply when it issued it. So The statute clearly contemplates some preemption, right? Here we have something of an answer to Professors Young and Benjamin, right? Congress is in there saying there's some preemption. The question is how much, right? And it was a high visibility decision. This was a decision widely covered in the newspapers. It was a decision for which there was some political accountability. The White House was involved. There are currently ongoing congressional hearings about the decision. And even though it was not a rulemaking, EPA still used a notice and comment process. They took public comment on the decision about whether or not to grant the waiver, and they also conducted public hearings. And finally, the decision is subject to judicial review on the same standard, I think, that Professors Galle and Seidenfeld would apply. So it'll be reviewed under the arbitrary and capricious standard, and EPA has already been sued. Ideally, this is the kind of determination where EPA would think about things like, is there an issue of local variation, and how valuable is it to have states serve as a laboratory of experimentation? It's this latter thing that EPA just didn't talk about at all. To be fair, they did, unlike many agencies, consider the value of local circumstances as a reason for states to regulate. And that makes the decision look like an advance over some earlier agency decisions on preemption. But they didn't put any weight on that, even though global warming arguably worsens some of California's air pollution problems. They certainly didn't consider any function that California might serve as a pioneer in regulating air pollution and the extent to which California might be a laboratory of experimentation for the rest of the country. So a couple comments about this. First of all, in my view, this is absolutely typical of agency consideration of preemption questions. I wrote an article in 2004 where I looked at agency analyses of preemption questions over the years and documented that out of hundreds of agency proposed and final rules, to the extent that agencies considered issues of federalism, they did so in the most cursory way. And if people are interested, I have some of the materials with me. And this is even though there is actually an executive order in place, I think cited by Professors Galle and Seidenfeld, that requires agencies to consider federalism issues. It's called the Federalism Executive Order. And even though that order's been in existence since the Reagan administration, agencies rarely consider the types of federalism issues that I think we would all like to see them consider. So what's the contrast? I think one contrast is Congress, actually. Congress is just, whatever problems Congress may have in terms of its transparency, as Professors Galle and Seidenfeld observe, or the quality of its discussions, it had much better discussions in these issues. In 1967, when these provisions were put in the Clean Air Act, in 1977, when they were amended, and in current oversight hearings, Congress has regularly talked about not only the need for states to be able to address local concerns, or for California to be able to address local concerns in the Clean Air Act, but the value of having California as a pioneer regulating auto emissions. So what's the reason that EPA didn't do a better job here and that agencies aren't doing a better job generally in thinking about these broader issues of federalism? One is, I can only speculate, but I have two guesses. One is that these are specialized institutions, right? EPA is out there to regulate air quality, to protect public health and the environment. It has a specialized focus. It hires people that are really specialized. As part of this paper, I looked at the current job postings for EPA. They never ask people if they have any expertise in general governmental structure or even constitutional law, unlike the Office of Legal Counsel, where Professor Benjamin worked before he went to teaching. They want people who know about constitutional law. Their EPA is not looking for con law people, and I think that shows in their rulemaking documents. And the kinds of statutes that they are asked to administer typically don't require them to develop expertise in these areas. It's not that preemption never comes up. I think it's just not a focus of the institution. Could this change? Possibly, and I'll get to that in a second. The other thing is I think there are poor incentives that may deter agencies from fully considering these kinds of issues. So agencies, as everyone has observed, have to present a reasoned analysis justifying their policy choice. It can be reviewed under the arbitrary and capricious standard of the Administrative Procedures Act. I think it is difficult to advocate a national policy if you are a federal agency while simultaneously saying it's preliminary. we don't really know the answers to these questions, and so we ought to have states continue to have authority so they can experiment and maybe they'll come up with better policies. In the context of the EPA action on the California waiver petition, EPA actually wrote to Governor Schwarzenegger and said, we're standing behind the Energy Independence and Security Act. That's our federal policy. That's going to fix California's problems. I think it's hard to acknowledge that maybe states could come up with something better. Now, that's not a case where EPA is actually setting its own auto emission standards. That's a whole separate story. But I think in the area where an agency is making its own choice, how much information should go on a pharmaceutical label? How much information should pregnant women get about mercury in tuna? There might be a concern about the agency, by promoting state regulation, also undermining its own policy choice in the court. So it adds an extra burden of defending its own ultimate choice as being well-reasoned. And that might be something where an agency's inconsistent statements in its own record, right, its own record of its own reasoning, might make it harder for it to win in court if judicial review is ultimately sought. So ultimately, as I said earlier, we all come out to roughly the same answer, right? Which is courts should listen some to agencies but not give away the store, right? There should be a fair amount of judicial review of agency actions that implicate preemption questions, right? There should be some deference, but not a lot. So what's the third point, right? What do we do now, right? Galle and Seidenfeld would say, let's enhance judicial review, right? That will improve the incentives for agencies to consider these broader federalism issues. My concern, though, is the statutes don't speak to these issues currently, or don't speak in great detail. So the concern would be that courts would have to come up with their own criteria for evaluating agencies' actions, and I think that would be a difficult function for courts to have to serve. All right, I think the better outcome here is to ask for more specific guidance from Congress. That's going to give more instruction for agencies, perhaps prompt them to develop the relevant expertise. Maybe they will start hiring con law experts at EPA now. And it will also give more guidance to the courts. Okay, so the last point I want to make here, I said there were 3 points, now it seems like I have 4, but what's my alternative, right? Professors Galle and Seidenfeld say we shouldn't have Congress making these preemption decisions or Congress primarily tasked with them. We should make it easier for agencies to do it because agencies essentially offer us easy preemption in appropriate circumstances, and they're not stuck with these difficult requirements of having to pass new legislation. It's not that they don't have any authority. The question is how broadly we read the authority that they already have. My response would be, say, this is true, right? It's probably harder to pass legislation than to do a notice and comment rulemaking. But we've got to have some judicial supervision. Everybody agrees on that. So what's the alternative here? Let's think about the two different scenarios, right? One scenario is the agency says we should preempt, right? Judges aggressively review the agency preemption decision and say it's not authorized, it's not reasonable, it's not persuasive, and the judges have made a wrong decision. The judges have wrongly construed the federal statute as not preempting state law. What's the answer here? What I want to suggest is that it's not so hard to fix the problem in Congress. We ought to go back to Congress. And it's not just that people who would like preemption will go to Congress, right? This is an argument made by Professor Hills of NYU, but agencies can go to Congress too, right? Agencies can join together with the folks that would like to see state law preempted and go to Congress. I think that's clearly a powerful combination. It's more likely to provoke a congressional correction of a statute that is wrongly interpreted not to preempt state law. And I think that's our best outcome. Right? Now, let's think about it the other way. The other scenario was the Seidenfeld and Galle scenario, which is agencies could get it wrong, but judges defer, right? And I think under those circumstances, it's much less easy to get the error corrected, right? And on balance, the alternative I think that we ought to have is a less deferential review standard by the courts of agencies, right? Unless we get some clearer indication from Congress that Congress wants the agencies to be able to preempt state law and under what circumstances. Okay, thanks.
I get to go first? All right. Stuart wants to be here to jump in if I say something wrong. I want to thank the Law Journal for including us in this symposium, and this is a good chance to thank the many of you here who have helped make me feel very welcome here, and in that regard especially my friend Stuart. I'll probably be making fun of him later, but I should say that at the outset. 2 points I want to make at the top before I launch into the argument. One is I've been living the paper today. I spent the morning at the state legislature in Raleigh trying to convince a committee that they were free to regulate the cable industry and didn't have to worry about the effect of preemption by the FCC. Whether that experience made me feel better about federalism, I'm going to reserve judgment on. The second thing I want to point out is that this paper is a minor miracle. It's a miracle that Stuart and I didn't kill each other while we were clerking together. On the first day of our clerkship, Stuart's first day, I had been there a while, we had lunch and we talked about kind of our basic views about the world. And in the space of about 10 minutes, Stuart managed to flatly contradict every single principle that I held dear. So it's really a maybe more than a minor miracle that we were able to write something together. The way we're going to do this, our paper really has 2 parts. One is that we reject the core focus on the agencies rather than Congress, and we agree on that, and I'll talk about some of that, and Stuart will talk about some of that. But then there's a second element, which is what is the relevance then of the analysis that Professor Galle, Professor Seidenfeld, and Professor Metzger have offered, and we actually disagree about that. So Stuart will go second, and he will give you his wrong view about that, and then I will jump in maybe at the end and straighten things out. All right. The title of our little opus is Tennis with the Net Down, and that alludes to a very famous interview that Robert Frost gave, that noted administrative law sage, where he was asked about free verse, and he said, I'd just as soon write in free verse as play tennis with the net down. And our view is that these papers, as brilliant, and they are wonderfully done, amount to playing tennis with the net down. And so part of the debate, I think, is going to be about whether that's a fair characterization. So let me just set out and try to summarize what I think they say, and then we'll talk about where we disagree. I think as a theoretical matter, this anti-Frostian position in these papers has really 2 elements. One is that the structure of our institutions should take whatever form best promotes public values. And then the second element is that the public values, we know what our public values are that we're promoting by looking at it in consequentialist terms, things like basic utility. In administrative federalism, in the particular context we're talking about today, this cashes out, again, to 2 things. One is that we can focus on agencies and not Congress to protect federalism. We don't ask, did Congress dictate the decision to preempt state law, for instance, and the agency is just executing that decision. We instead ask, is the agency itself set up or acting in such a way as to protect federalism? And if they are, then we're happy. And then the second thing, the second element is that the only kind of federalism that counts is the consequentialist kind. Federalism is a value to the extent that it increases the general welfare, not for obstinate reasons like it's in the Constitution or something like that. Now, Professor Metzger, we may not be able to prove the second element beyond a reasonable doubt with respect to her, although we do have our suspicions. But I think she's definitely in for the first one. Now, we think, on the other hand, and shockingly we agree on this, I believe, that a focus on Congress is hardwired into the Constitution. It's hardwired into the Supremacy Clause, which only talks about 3 kinds of supreme federal law, none of which are agency regulations. It's hardwired in the vesting clause of Article 1, which vests the legislative power into Congress, and it's hardwired in the procedural clauses of Article 1 that say, this is how we make a law. Many of you, I hope, are not too old to have grown up, or young to have grown up on I'm Just a Bill. They didn't say anything about administrative agencies in that little song. All right. So for us, that means that everything the administrative state does, especially when it's preempting state law, has to be grounded in the will of Congress, has to be tied somehow to a decision that Congress made, not that the agency in its wisdom made. So this is really, our paper is at bottom an exercise in analytical stubbornness. We are not prepared to give up this idea that there has to be a link to Congress, no matter how bright and shiny the agencies are, no matter how smart they are, no matter how much smarter they are than Congress, even if you could show me that it would be better for federalism, in any sense in which you wanted to define it, that the agencies make this decision. We're prepared to be obstinate about the fact that Congress has to make the decision because that's what the darn Constitution says. Now, we think this constitutional focus is the net across which constitutional law is played. If you take the net down, if you shift the focus to administrative agencies that aren't even in the Constitution, then you're not playing tennis, you're playing beer pong. All right. Now, Professor Galle and Seidenfeld portray our disagreement as one between realism and formalism. Now, I think this is itself an interesting question. They've kind of walked into another project of mine, and so I'm going to belabor the point for a minute. Their version of legal realism, or the kind that is in administrative law, seems to be something along the lines of a country's got to do what a country's got to do. And I don't mean that to be flip, but just to say that we have to do what makes institutional sense. We have to do what makes functional sense in terms of reaching good outcomes in light of contemporary reality. That's how we structure our institutions, and we can't be too hidebound to structures that were written in 1789. Now, that's a plausible view of realism, but I think there's another view of what legal realism might mean in the context of constitutional law. And this is kind of an interesting and obscure question because the realists mostly didn't talk about constitutional law. They mostly talked about private law, property and tort and contract. But they did have some things to say about constitutional law, and shockingly enough, Stuart and I both find ourselves in that camp. But I want you to bear with me a minute because I think this example will be easier to understand if we start not with legal realism, but with comparative constitutional law, and I want to talk just a second about England for reasons that will become apparent. The English don't have a written constitution, right? Famously, they do not have a single codified document that sums up their institutional arrangements in the way that we do. There is a subject of constitutional law in England, and the way that constitutional law is defined is that every law, whether it's a statute or a practice or a regulation, every law that performs a constitutional function, and by that I mean the constitutional function of setting up the institutions of the state, every law that does that is part of the Constitution. And so in a class, you wouldn't have a class on just constitutional law, you would have a class on public law in an English law school, and you would study all those laws. That would be the sum total. So it would be administrative law and some other stuff all crammed in together because it all serves a constitutive function, and that's what constitutions do. They constitute the state. All right? And I want to encourage you to think just for a moment about the U.S. Constitution in the same way. What if we thought of all the laws that constitute the state as part of constitutional law? Then what would the Constitution encompass? Well, I think it would encompass a lot of things besides this canonical document that was ratified in 1789 and then subsequently amended. If you think, for instance, about what constitutes the separation of powers in our modern state, you think about the Youngstown test and the Steele seizure case. The boundary between the president's power and Congress is defined by statute. He is able to do what Congress has authorized him to do. He is forbidden to do what Congress has forbidden him to do. And in order to determine the boundaries of his power, you have to read statutes and treaties and things like that. Witness the Medellin case a couple of weeks ago, witness the Hamdan case a couple of years ago. That is the analysis in separation of powers today. Think about the administrative state. Think about the role of the EPA in clean air and water cases. Here is a vastly powerful institution of government. It has three branches. It hears, it decides cases and adjudications. It legislates. It makes rules. It enforces. It prosecutes. So it has an executive, a judiciary, and a legislature, right? And there are rights that individuals have against this government, and all of this is codified in the statute. None of this is in the canonical Constitution. And I would say that these statutes and regulations and practices are all playing a constitutional role. They are constituting the government. And now we can turn back to legal realism, because that's exactly what Carl Llewellyn said about the Constitution back in the 1930s. He said, we have a working Constitution, and it's a lot bigger than you think. It's all all these institutions that describe the way that the government actually works. So this is what realism means to us. It's a hard empirical look at all the institutions and practices that perform constitutional work in our system. Now, what does this have to do about anything? Well, one thing it means is that there's lots of room to mess around with the structure, because the hardwired part, the textual part from 1789, doesn't really answer that many questions. And most of the constitutional work is being done by ordinary law, statute and regulations that can be changed over time, that can be adapted to changing circumstances. And this is probably why our Constitution is not just irremediably broke. Right? But we do deny, and I think Llewellyn would have denied too, that the hardwired parts, and there are some of those parts, that the hardwired parts can be shifted aside. And I think that's the difference between our version of realism in constitutional law and their version of realism in constitutional law. Now, they say, and this is most explicit in Galle and Seidenfeld's paper, that the alternative to their view of realism is a form of formalism. And I don't think that's quite right. I mean, I think of formalism as bright line rules, the application of which has nothing to do with the underlying reasons, shutting out institutional realities, not paying attention to function. This Constitution outside the Constitution, when you take this broader version of the Constitution, very functional idea. We're looking at the actual roles that laws play. And so I think both Stuart and I are prepared to be pretty functionalist in our analysis. I'm functionalist enough, for instance, to think, in evaluating Professor Metzger's argument, that if the states always lose under her version of federalism, that's not a very good version of federalism, right? But disregarding the hardwiring of the Constitution, setting aside the Article I, Section 7 process for legislation, for instance, that's not functionalism, that's write-your-owism. And Stuart is going to talk about the way that plays out in the particular context of administrative law.
That was very fast. That was very impressive. Ernie's wrong about one thing. He told me later, actually, it was our first conversation, even before actually we had lunch, even before I started work, in which he said the hair in the back of his neck was standing on end after he had met me. So yeah, it's all the more remarkable that we can write this. And I'm now going to talk a little bit more, but also talk about some areas that are actually sources of debate between Ernie and me. So this is a response to their article, but also a little bit of a back and forth between us. So just picking up where Ernie left off, there's one obvious response that you could have to any sort of attempt now to invoke any meaningful constitutional constraints on the administrative state, which is to say, that ship has sailed. It's just too late in the day. We now live in a world of the administrative state, and you trying to now say, oh, this is going too far. Sorry, in for a penny, in for a pound. Now, our response to that is, well, actually, all along, when people who cared about the delegation doctrine, people who cared about Congress's interpretation of its interstate commerce powers getting broader and broader, people who cared about a role for states in the federal process, all along, the response to those people was, well, don't worry, Congress is still there. You still have the political and procedural safeguards of federalism, about which I'll talk more just in a second. And if we go the Galle, Seidenfeld, and Metzger route, I think we've given up on that. Now, again, their response might be, well, that's not such a big step. But our response is, but that's if we're giving up on that deal, then we don't have a deal. And if you want to say you never cut that deal, that was a deal that was cut in the 30s before any of us were born, great. Then we don't have a deal either, and then we have to go back to first principles of administrative law and try to actually justify the administrative state. And what do we think are these underlying formative principles? Well, it really is, as I just mentioned, the political and procedural safeguards of federalism. It's very hard to get legislation passed in Congress, right? Bicameralism and presentment is a hassle. And I take at least as dim a view of Congress as Professor Seidenfeld does. I yield to no one in the dimness of my views about Congress. This is not an argument about if I were creating a constitution how I would write it. I might very well create a cost-benefit state. I don't think it's the state that we live in. And then there also are the political safeguards of federalism, which are, again, something that was central to the way this system was designed, that states were going to have representation through the Senate, through the House. We might not like it. You know, we can talk till we're blue in the face about how ethanol policy is a function of state representation in the Senate and what a terrible idea it is, and I'm going to agree with you. But I do think that's the system that we've created, and I think we should be very uncomfortable with a world in which we blithely ignore that. I mean, after all, what we're being asked to do is to say, well, agencies will do a pretty good job here, so we should take some comfort in that. Now, we aren't talking right now, but we're sort of bracketing the question of whether agencies will in fact do a good job. But just think about this, about the position we're putting agencies in. This came up in the Whitman trucking case, a delegation case, in which one of the arguments made in defense of the delegation by the agency was, oh, don't worry, we will restrict our own power. To which the court said, well, wait a minute. If you're able to restrict your own power, then this obviously shows the breadth of the delegation in the first place. If you can now create a rock so big that you can't move it, then in fact, you have all of the power. That can't be right. And this is the, sort of the nub of our concern, that fundamentally, there's no getting around the centrality of Congress as representative of states through its membership, Congress as the touchstone for all action that gives whatever legitimacy agencies have has to go through Congress. We think of that as being boilerplate, right? I mean, part of the problem with our position is, we're sort of just, we are, the old joke that some conservatives are standing athwart history yelling stop. And, there's a degree to which we're doing that and we plead guilty, but we think that principle has to be there, that the touchstone has to be what meaningfully we can attribute to Congress. So now I get to the part where Ernie and I are going to disagree. What I would say about that is two different areas where he and I might disagree. One is, if I can attribute that will to Congress, then agencies go wild. This is the part that Ernie doesn't agree with. So I'm willing to engage in lots of interesting questions about institutional analysis. I engage in comparative institutional analysis, but I do so on the notion that Congress has in fact delegated something to an agency, because then the other area where we disagree, I don't care what agencies have internally for their own functions. So this is where I actually would disagree with the consensus that Nina is talking about. I'm not very interested in agencies' attempts at protecting federalism. I mean, fine, it's nice, whatever, makes you feel good, sing kumbaya, but I think it's got nothing to do with the constitutional analysis. It shouldn't, to my mind, shouldn't make anyone feel better about the larger questions about the legitimacy of agencies acting in the first place. And so my own view is what they're talking about is perfectly nice, is my own view irrelevant to the larger constitutional questions that motivate me. And one way I would, again, Ernie is going to disagree, but I want to get this out. One way that I would put this in administrative law terms is this question that Nina mentioned at the very end, which is, so let's imagine that we do want courts to take cognizance of the role that agencies are playing here and say, oh, you're playing a federalism reinforcing function. What I want to invoke is an old administrative law doctrine, which is that in some situations, courts can't actually meaningfully oversee what agencies have done because there's no law to apply, because Congress simply has given no meaningful legal standard for the court to sink its teeth into. And what I want to say to you is, when I hear about concerns about, well, this is going to be relevant to federalism in some kind of way in court, I feel like, what am I actually able to tell the judge that the judge is supposed to look to? I feel like I've got something to say. Look to Congress. Has Congress given the authorization? once I'm in this world of, well, agencies will engage in some protect, I have no idea what the metric is that I am asking the judge to utilize in order to evaluate that. It just feels like it's a nice thing and we can throw it in the brief and everybody can feel good, but it feels to me like an example of a situation where there truly is no law to apply. And so back to an area where I think Ernie and I might agree, the concern is that it ends up just being a fig leaf. So it's something you throw in, just like agencies are supposed to throw into their orders, oh, we've looked at federalism concerns and this is why they're responded to. Now, Nina's work has shown they don't even do that. They don't even bother with the fig leaf. In reality, the agencies don't. But the point is, if they did add the fig leaf in, why should that make us feel good as a matter of the constitutional structure? Again, maybe we think it's fine as a policy matter. Okay, that's not my federalism doesn't motivate me as a policy matter. I just think that we've gone beyond, we've stretched the Constitution beyond where it can go, and again, my view more than Ernie's view, and so I feel like we now end up with a focus on something that, to my mind, is a sideshow. It's neither necessary nor sufficient, and in my own view, again, different from Ernie's, I don't even find it terribly useful. I just don't care that much about what agencies, what their procedures are, what they say, et cetera. If I'm a judge, all I want to see is the authorization from Congress to the agency. That's the thing. That's the thing that I feel like I can get some sort of grip on as a judge, and that's what I want to urge judges to try to invigorate. And it's not easy, but at least I feel like I've latched onto something there that's actually in the Constitution, as opposed to getting to the agency point where I'm so far off in Never Never Land that I don't even know what to tell the judges at that point. Now, Ernie, I'm sure, wants to disagree.
I think if I'm a judge, coming from Professor Benjamin is probably the scariest thing I've heard in a while. I just want to apologize for subjecting you to all that wrongness. Let me just make a couple of points. One is that even if you comply with the hardwired features of the Constitution, the legislative process vesting in Congress, all of that, it only takes you so far, and the system is likely to drift out of kilter. And I think the Constitution also embodies a more basic commitment to balance in the federal system. And I think this imposes an obligation on all three branches to compensate for drift in any particular direction. And we have to think about new and innovative institutional ways to compensate for that sort of drift. And so I think much of the stuff that Professor Galle and Professor Seidenfeld and Professor Metzger have talked about is just tremendously useful in that regard, in proposing additional mechanisms that could be built into the process to do something to really restore some balance to the system that has largely disappeared in the past century or so. And so I would welcome all of that, because unlike Professor Benjamin, I do care about states. Stuart is one of my friends that used to say that the only thing states are really good for in a normative sense is choosing flags and birds. And then we had the whole thing down in South Carolina, and now we're down to birds, not flags. I actually care a lot. And so I care about finding institutional mechanisms to protect federalism. And so that's why, at the end of all the nasty things I've said about their theoretical position, I can welcome the functional analysis of these papers as extremely helpful, and I'm very glad to have it. Thanks.
Well, thank you all. We're going to have a panel discussion now. As Destiny comes to set up, I would like to invite all of you to a reception, which we'll be hosting just outside as soon as we finish here. Would also ask our guests to come join me up front. At the reception outside, some of the attorneys from Jones Day I mentioned is sponsoring the event will be here and available to talk. Please do feel free to approach them. And I think what we'll do is I'd like to give Professors Seidenfeld, Galle, and Metzger an opportunity to open up our discussion and maybe respond to some of the points that the others have raised. And then we will take questions both from our panelists as well as from the audience. So let me hand things over. Maybe we will begin from this end of the table and work down.
Sure. I have one thought that maybe is this on? Can you hear me? Yeah. Okay, good. That I'll offer first because it covers at least two of the papers, although it doesn't get to the last one. So I think that Professor Metzger's paper is helpful to us in some senses and is a challenge to us in others. And one way that it's helpful to us is in sort of fending off some of the arguments from Professor Mendelson, and in particular, her pointing to the EPA California waiver example. Right, and Mark, at any point, should feel free to stop me and tell me that I've gone all wrong. But I mean, as she says, it's a difficulty for us because if we're right that agencies are so good about thinking about federalism, they seem to have fallen down there. One thing we'd say is we haven't seen the judicial review yet. But the other thing that we'd say, and this is where even the positive part of Professor Metzger's paper is really helpful to us, is she says, look, courts just haven't been that explicit yet about asking for agencies to think about federalism, so maybe it's not really so surprising that they actually aren't thinking about federalism. So that's one thing that we can say in response to the historical arguments, at least, that we hear from Professor Mendelson. On the other hand, her prescription at the end that it's wiser for courts not to be explicit in asking for federalism deliberations is a problem for us because that's a central claim of our paper, is that that's what agencies have to do. But I think her point is that that comes at some cost. And I want to call this the administrative law is boring point, which is that I think her claim is basically that courts figure no one's really going to poke too closely into the details of administrative law determinations. You'll hear states' rights as a political rallying cry, but you probably won't hear notice and comment from any political party's platform anytime soon. So if courts want to get results and minimize political resistance, maybe they should be sneaky about it and use administrative law. And so we have to deal, I think, with that tension in our paper.
I'll start with Professors Mendelson and to some extent Professors Metzger. I have an interesting thesis which I really need some help in analyzing whether it's true, but I actually think that Professor Metzger agrees with us and Professor Mendelson doesn't on the ability of judicial review to really alter the structure of agencies. And I think if you historically look from 1968 to about 1975, you will see that because that's when a combination of NEPA and hard look review were created. And if you look at agencies before that, they were pretty one-sided. They were pretty much, we have a role, if you look at the Federal Power Commission before FERC, they had their engineers and they just, they did their thing. If you look, it wasn't until the court started saying we want to consider all relevant factors, and the factors that were relevant were beyond those that were explicitly mentioned in the statute if they were quite obviously relevant. And then agencies had to hire a whole different kind of staff members, and you had different offices. You had economists and scientists of different ilks and different training coming into play, and that created, if you will, within the agency almost a set of groups with constituencies that could try to reach consensus. And I think that's correct. I can't prove it, but it certainly that those two things did happen. Whether one was the cause of the other, I don't know. I think that the kind of judicial review we're asking for, if I'm right, would cause the same kind of change in agencies. And I don't think it would be con law scholars, though. I do think it would be the kinds of people who look at policy analysts and economists who would look at structure of government, not law people, but policy people who would say, what is how certain are we of the benefits that we have? What benefits are we getting? And what are the potential costs here? And what are the costs of non-uniformity and experimentation? I think that agencies are capable. It wouldn't be lawyers, by the way. It would be, as I say, it would be probably people trained in economics and policy analysis, I think. But I think there's a lot of potential there. For that, and the answer is, as I said at lunch to another professor who I was eating lunch with, me too, Galle, I said, whenever I make statements, I always make sure that they can be as controversial as they want, but they have to be non-refutable in the sense that, no one can refute me because nobody knows. I'm using a counterfactual world, but I do have that optimism and notion. I would like to pose a question to Professors Benjamin and Young here. I think in a funny way, I feel like I've only seen this in passing, but the deal, no deal show, I want that box. I'd say no deal to Professor Benjamin. I'm not buying the deal because I think that he's already in for the penny and the pound, or he's really going to have to go back to basic principles. Let me just pose this question. Maybe I'm wrong. Maybe he's not bothered by this, but their structure of the Constitution assumes that the word law in the supremacy clause does not include agency regulations, essentially. And I want to know, when the agency regulates under statutory authorization from Congress and says explicitly, you must do X, whatever X is the state free to then tell the person, you may not do X? And what does the person do in that situation? Because their notion of preemption, we've been talking about preemption, as Tom Merrill says, of displacing agencies when there's no direct conflict. But their argument would say that even when there is direct conflict, the state can tell the person, you don't have to listen to what the federal government has told you when they have been authorized to do this. And that seems to, I'd like to see their reaction. I'm interested in their reaction to that, because that seems to me to go pretty far.
Okay, I love these responses. Let me begin with Nina's, because I think the example of the EPA waiver is a great one. And I think it shows a couple things. One is, I think it shows you can't avoid the administrative law angle. And that is because courts can't grant waivers. So we're really talking agencies or Congress. And whatever you think about Congress's needs to legislate more specifically, Congress is not going to be able to grant specific case-by-case kinds of waivers. This is the archetype of what has to be delegated to administrative agency. And I think it's a great example for showing how we're not able to avoid the need to make agencies sensitive to state interests in our current regulatory schemes. And I think it's very helpful for that. And it's not the only, you see waivers coming up in No Child Left Behind. You see waivers coming up in terms of Medicaid and whether you can raise the poverty threshold. This is endemic to administrative government, and I think it's a good way of showing some of the complexity that goes beyond preemption that we need to be taking into account. I'm also not convinced it's such a story of agency failure. One of the points that Nina mentions in her piece is that in the past the agencies had granted the waivers. And this is a deviation from what they'd done in the past. Now, it's also a substantially different question because it's global warming, but I think that's significant. And when I see this waiver, I do actually see politics. I see the Bush administration's desire to prevent any regulation of global warming, stage 2, I think actually if we focused on some of the things about specialized agencies, we would actually think that the agency in this case would be regulating, that the specialized staff might very well be more sensitive, would be granting the waiver, and so what we see is really more of a political intervention. And in that sense, I see it as sort of on a par with other instances in which agencies have taken political direction. We can debate whether or not they should. It goes to whether or not it's within probably Congress's authorization, but administrative law has always dealt with that. So I see this as sort of falling into that camp. And a good example of how the real threat here may be politics. Sorry, that's the phone already? Again?
I don't know why there's a phone there.
Than anything else. On tennis with the net down, no one else has managed to convince me that poetry and administrative law had anything in common. I am so impressed. But, well, I honestly think that the tennis with the net down today is trying to get specific congressional authorization for decisions by agencies that displace state law. Or put it differently, I think a whole lot turns on what you guys count as meaningfully traceable. If meaningfully traceable has any real substantive bite on it, then what you're really talking about is a significant curtailment of federal regulatory authority of a kind that would, I think, significantly transform our government and society of today. And I need a whole lot more account of why the Constitution mandates that, and not just that it was originally expected, blah, 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 but also why today, with the world as it is, and with doctrine as it is, and with all the assumptions that we've come to rely on, it is at all normatively legitimate, or one can make a claim of constitutional principle that we have to go back to that. And this relates, of course, to bicameralism and presentment, right? I mean, the argument that the Constitution embeds bicameralism and presentment and wants to make the federal government's legislating difficult is exactly the argument against delegation. I'm not sure that I see how you can stop being in more wholesale unless you're willing to call that into question. If you're going to call that into question, then you really face, I think, a challenge of trying to dramatically transform our current society. And I think Nina faces a little bit of the same question. And part of the issue here, something that Mark just referred to, the issue really is how do we pull out preemption or other kinds of decisions from everything agencies do? If we have a world of concurrent authority, and I think we do, then the question is, how do you allow federal agencies to exercise their delegated power, which is going to displace state authority? And if you say that the federal government and agencies can't do that, that's when you end up significantly curtailing the federal government. If you want to say they can, then I think we're pretty far away from any kind of constitutionally mandated specification requirement. We are talking about degrees in a way in which what we might be talking about is, whether the net can be 2 inches lower. But on this, great poems aren't written.
Great. All right. So I want to just make a couple quick comments in response and then add to the long list of questions for Professors Benjamin and Young. I think I actually want to raise a note of agreement rather than disagreement with Professors Metzger and Seidenfeld and Galle. I do think judicial review can help. Could agencies do a better job if they had better judicial review? Absolutely. There's no question that arbitrary and capricious review has, over the period of time that Professor Seidenfeld mentioned, made for a great improvement in the quality of agency reasoning, and that has resulted in agencies being more careful about their economic analysis, about their science, about explaining their reasons for choosing one conclusion over another. What's the problem with preemption? I think Professor Benjamin, gave the answer that really I should have given, which is on federalism, there really is no law for the courts to apply yet to agency decisions, and I think that is a problem. Most of the agency statutes that we are talking about are framed in terms of the substantive policy goals that the agencies have to implement, and not in terms of the broader notions of constitutional structure or distribution of powers among levels of government that I think are properly implicated in a preemption question. The second comment I want to make is in response to Professor Metzger on how can we distinguish preemption from any other sort of question that an agency has to decide. Why is it that I, for example, should say, perhaps you can have Chevron deference on a question of how to implement a particular part of the Clean Air Act, but not if it relates to preemption of state law. And I guess the only point I would want to make here is agencies have very general delegations of authority, but the courts have consistently applied them to have limits. So, for example, courts do not defer to agency decisions on a question of how to apply the Constitution. Should judicial review under a statute be foreclosed completely of constitutional questions? That is not a question to which a court would defer, on which a court would defer to an agency answer. And I just think preemption belongs in that category of questions. And I think it belongs in that category of questions because it raises broader issues in which we don't have any reason to think agencies are expert. Lastly, I have actually one other comment in response to Professor Metzger. The California waiver example, it may well have been political. I think a lot of these decisions are political. But ultimately, I think that is about the outcome. and not about the quality of reasoning. It's still going to be subject to judicial review. You might say accountability to our only nationally elected official is a good thing in terms of agencies attaching the correct weight to state interests. But either way, we ought to have seen a better reasoned analysis, whatever the outcome is, and whether the choice of what decision to make was politically motivated or not. Okay, lastly, my question for Professor Benjamin Young to add to your lengthening list. We've got lots of statutory delegations of authority to agencies that say the following. The Federal Food Drug and Food Drug and the FDA is authorized to promulgate any regulation necessary to implement the Federal Food Drug and Cosmetic Act. The FDA thinks effective administration of this act should entail preemption of state law if state law would take us in a different direction than the FDA wants to go. Is that enough to meet your Article 1, Section 7 requirements? You've got a statute on the books. It gives the agency authority. Preemption of state law, you might say, is a good idea under the statute. Is that enough for you?
All right, Ernie wants to go first, and then I'll hit whatever he doesn't hit, and I disagree with half of it anyway. Go.
We're gonna strike a blow against alphabetism. So I think it's telling when Professor Seidenfeld says that the new people that should be at the EPA are not law people but policy people, because I think a lot of the difference between us is that we think of the constitutional structure as law, as fundamentally binding law and not a matter of alteration according to policy, even if that's a bad policy idea. That's what it means to tie yourself to the mast when you ratify a constitution. Now, administrative regulation, I think, has no independent preemptive force other than what derives from the force of the statute that it is implementing. Now, to be sure, administrative agencies fill in the gaps of the statute, and when they do that, that would have preemptive force, but it is tied to and derivative of, parasitic on, the preemptive force of the statute itself. There's a difference between filling in and making new. And that's the difference between playing tennis with and that or without. The same thing is true, by the way, of federal common law. When federal courts make common law rules, they do so in the interstices of statutes, and to the extent that they are filling in the gaps of the statute, those rules are supreme federal law. But they don't think that they have the authority to just go off and make new rules. And in the areas in which they do that, like admiralty, that's unconstitutional. And the same thing is true in constitutional law, for instance. A judge-made rule has the force of the Constitution itself only when it is directly traceable to the Constitution itself. And if a judge tried to make up a rule just because he thought it made sense on policy grounds and make it a rule of constitutional law and trump a federal statute, we would laugh at that. We would say it doesn't have the force of the Constitution because it's not filling in the Constitution, it's not implementing the Constitution, it doesn't have the force of constitutional law. So I think administrative law has no independent preemptive effect, but a lot of regulations can preempt because they are implementing a federal statute. Now, I don't think that our position depends on this argument, actually, because I think you could take the view that agency-produced law is supreme within the meaning of the Supremacy Clause, but that agencies are only authorized to make it when they can tie the authority to make it to some kind of congressional enactment. That would be a fallback position. I wouldn't be quite as happy with that. Stuart might like it better. Now, meaningfully traceable. Gillian is absolutely right. A lot depends on what meaningfully traceable means. But I perceive what is new and original and striking about these papers is the idea of shifting the focus from Congress to what happens at the agency. Right? And our argument is a reason to worry about that shift in focus. Right? The more you shift the focus, the more troubling that may be. Now, it may be that there is some kind of middle ground where you shifted the focus some and paid attention to what goes on at the agency, but there's still some significant connection to the underlying statute, and it might be that we could all happily live together on that ground. I don't know. But I think our only bottom line here is that you cannot abandon the tie to what Congress does entirely. Right? And then we can fight about how much you have to be able to tie it back to that. Now, the question about whether we want to strike down the administrative state, the reason why administrative law is a more fruitful area to think about federalism than, say, the Commerce Clause is that it's not all water under the bridge yet. That water is going by right now. Right? And if you think this stuff doesn't affect your lives, then you are just wrong. I mean, the Bush administration's broad view of executive power is not just taking place at Guantanamo. It's taking place in these efforts at the FDA and the EPA to just write in preemptive rules into statutes where there's no connection in the statute itself, right? And there's a lot of power grabbing going on there. But it's not like the architecture of our present institutional arrangements are just predicated on broad views of administrative preemption. These questions are still open questions in many areas of administrative law. What kind of deference the agency gets on a preemption question, whether the agency has independent preemptive powers apart from the preemptive force of the statute. There aren't huge bodies of institutions built on those principles. Those are things that are still open to us to decide right now. That's what makes this so interesting, because there's still a possibility to do some good in this area. The Commerce Clause is gone. My answers to that question are in the other paper, which Gillian hasn't seen, but which I will give, and Stuart would never go along with my answers to those questions, so I'm going to desist about that. And then finally, an answer to Nina's question, I think the power to preempt is analytically separate and functionally separate from the power to fill in the gap in the statute and make a rule. And Stephen Gardbaum has done work on the difference between preemption and the supremacy effect of federal law. And I think there are meaningful distinctions there, which are highly technical, which I don't want to get into there. But yes, I mean, you may have to concede some power to the agency to take those sorts of action. And those actions may have independent preemptive force, and it may be impossible to hold that fire break. But what about the cases where the OCC, the Office of the Comptroller of the Currency, just without pointing to anything at all, writes the Commissioner of Banking in Iowa and says, your rule on this is preempted because I say so, right? I mean, that's unconstitutional in my view, and it doesn't raise these sorts of problems, and there's lots of instances like that, these preambles, for instance. So I'll desist and let Stuart.
Right. So I agree with most of what Ernest said, which is a higher percentage for us than ordinarily is the case. But let me take a slightly different crack at the answer, and note that there's a way in which the divergence from Ernie and me puts us in a more radical position than either of them, though in opposite directions. So the way I would answer this question is, I want to actually try to use whatever I think are the appropriate statutory construction mechanisms to try to see what I think Congress intended. When Congress was creating the FCC and said you can make laws consistent with the public interest, convenience, or necessity, if there's a good argument, and by the way, there is with respect to the FCC, that they intended agency to be able to run roughshod over states, to do anything it darn well please, my answer is, then more power to you. And again, I don't care then what the FCC does about preemption at the FCC level. Just doesn't matter to me.
What if we don't know?
Pardon me?
What if we don't know?
No, but I'm saying, all I want to try to do is use whatever tools of statutory construction that I can. And that's where Ernie and I are going to have a fight about this. Ernie's going to want to see a lot more, and that's why I'm saying where he and I are really going to diverge. I might end up giving much more authority to agencies than any of these people are talking about. Ernie might give them much less. I'm just saying, for me, I want the battle to be about what is the statutory interpretation that we are engaging in. What assumptions do we make when, as Nina was just saying to me, when it's not clear what Congress did, right? That's the billion-dollar question in administrative law. That's what I think the focus should be on. I will just tell you, I personally am very wary about imputing intent, which is what Chevron is. That's another story. But that doesn't answer the question of, all right, so we've got this statute, and how do we try to make sense of it? And as I say, it may very well be that we think the best interpretive tools and techniques that we have will lead to a result that's way beyond where these are, and again, we'll make the hair on the back of Ernie's neck stand up. That's fine with me, but I just think that's got to be where the focus is.
I'm breaking out in hives.
Yeah.
Do you want us to take questions?
Yeah, I think we should. Is there any question?
We can argue it over dinner, so.
Questions from the audience?
We'll get some.
Yeah, Sarah.
Both Professors Seidenfeld and Metzger, I think, mentioned that one of the virtues of agencies acting in this area is that agencies in some ways are more accountable than Congress. And I'm just wondering what your thoughts are on to whom are agencies accountable? I think that's the problem that I have with that assertion that maybe they're more responsive, but not necessarily responsive to Congress, not necessarily responsive to the state. So where does that accountability come in?
I think that they're accountable in the sense that they have a lot at stake before they can displease the political branches. And they are, I mean, obviously Congress has a lot at stake before it displeases the public, so you have a double agency problem. But I think that the connection between Congress and the agencies is sufficiently close and superior to Congress in the sense that Congress can act more easily by influencing agencies than it can act by itself enacting legislation. Now, of course, in both cases, you have the president. I mean, a lot of what's happening here is, all of these issues and Congress being upset. If this issue had come up 3 or 4 years ago, Congress would be very supportive. You would have had a Republican Congress. You would have had the president. Everybody would be behind it. There'd be a lot of disgruntled people saying you shouldn't do this, and it wouldn't have gone anywhere. It's the fact that we have divided government again that is creating the opportunities for this. And so, so you do have that problem that when you have divided government, to whom are you responsive? But that's always true of Congress. Congress only can act by legislation by overcoming the president's veto. And so in this situation, I think that you're responsive to Congress in a way that's more meaningful, not in the sense that it's any easier to overcome the president's influence or anything like that, but in the sense that it's easier to act, and because it's easier to act, you can reflect current preferences rather than have to wait 10 or 15 years before the issue gets so hot or so bad that people just say enough's enough. We've overcome the costs, which may never happen. Now, and I think the judiciary is worse. One of the, we can debate the Lochner era all we want, but one of the problems with the Lochner era was I think that the judiciary got about 35 years out of touch with what the people wanted, and that was a problem. And then it corrected itself very quickly in 1936 and on. So that's the sense in which I'm using. I mean, they're responsible in the same way that anyone's responsible to the people. There is an agency problem, but I don't think I think that's a lower cost, a lower problem than the problem of the time lag due to inertia of congressional adoption of substantive legislation.
I guess what I would add, because Mark's pretty much covers the ways in which you get political accountability. I mean, accountability, it's a fascinating term, but a lot of the discussion is what does it mean to be accountable, and there are different forms. And we tend to think that what you need to have is this kind of direct electoral accountability. We could discuss the extent to which we, our non-competitive federal elections, for the most part, we actually get so much accountability. But a lot, I think, of what's more interesting is to think about accountability in a slightly broader frame, which we see happening in a variety of legal areas, but not trying to be able to claim some kind of direct electoral account, but you talk about professional accountability, you talk about implementation accountability. I mean, if you're relying on the states to implement a program for you, that gives them a lot of internal influence and means that they can both force you to wield their influence in terms of the choices that you can make. And then you do have the indirect political accountability and the ways in which you can force the political safeguards to work. But I also think that focusing just on political accountability is too narrow a frame.
Whether there's in a way that sort of the resistance that you've talked about within Congress in terms of slower action and sort of needing to do all this deal making and whatever isn't actually something that is perhaps even built into the Constitution to enforce federalism, in the sense that perhaps in the wake of, say, a September 11th type thing, it's easier to get kind of this kind of inertia going where you want to act, and that maybe there's the braking system in terms of the legislature comes from this kind of deliberative, and that may actually protect the states in a certain way. And also, similarly, in the judiciary, you gave the Lochner example, that sort of this kind of adherence to more of the structural type constitutional issues may actually be a protective device against that. If I'm making it.
I think you're right. I mean, if you were to look at the original purposes behind bicameralism presentment. It was to make legislating hard, and that was a fear of federal power. I think the problem is, this is where I get to the, this ship has sailed. I think that ship has sailed. I mean, I think the reason why that ship has sailed is because if you take it seriously, it prevents what this country wants at the national level, what this country needs at the national level, and what this country, you wouldn't have our government, our society of today. That's not just a functional argument. I actually think it's a question of constitutional principle, because I think at that point, Mark's point about the system being too out of whack with popular views becomes quite pressing. I think it really calls into question the legitimacy of enforcing the Constitution and would lead to a constitutional crisis, and in fact did, and that's partially why that ship sailed. But I think you're absolutely right, and I think it leads then to a lot of Ernest scholarship about how do we, taking that ship have left, try and nonetheless give meaning to federalism, and this is where I get the sense that Ernest and Stuart surprisingly aren't on the same page about whether or not you can try and still harnessed by bicameralism presentment, for example, by clear statement requirements, or, is that an undue intrusion onto congressional power? And I think that's certainly a debatable question, but you're right.
If I could just add, so we'd agree that if you're a Burkean, then the fact that legislation is uniformly more difficult is probably always attractive, because you're keeping the status quo. But our point is that from a federalism perspective, inaction isn't always appealing, because there may be some instances where you need action in order to get closer to what federalism seems to prescribe.
Other questions? Doug.
So I have a question for Professors Benjamin and Young. You unquestionably put the focus on the hardwire requirements that are in the Constitution. But my question is that the end of the inquiry, once it's been answered in the affirmative, that this is in fact meaningfully traceable to some grant of power given by Congress? Is it then, is the administrative state then constituted in the way Professor Llewellyn's working Constitution, or the Constitution within the Constitution, Professor Young, that you say, is that, or outside of the Constitution, I'm sorry, or are there additional questions to be answered at the beginning? And I think along the lines that Professor Mendelson pointed out, that questions like, if there is preemption, how much? Is it just a threshold that once you're over it, then that's the end of the ballgame, or are there additional steps to the inquiry?
This is where we disagree, with the two of us. And I think it comes down to whether you would read the Constitution to include simply a set of rules and structures, or whether you think there's some kind of background logic to those structures that has some kind of independent gravitational force. And I think Professor Benjamin will, he'll get the answer too, but would say no, and I would say yes. And that ought to guide, that gravitational force ought to guide the development of the Constitution outside the Constitution. So, Congress or the president, take the president, please, ought to say, look, we've got these hardwired structures, they're doing some good, but we continue to be way out of whack in terms of, the balance between the nation and the states is imperiled, and so I'm going to do something like the executive order requiring agencies to think about federalism. Or if you're a court, you could say we've got a lot of freedom to develop administrative law under the APA, and I think, I've read Professor Metzger's article, and I think as part of my constitutional obligation to formulate doctrine to compensate for drift, I'm going to take some of her advice, and I'm going to use hard look review to ensure that agencies think about federalism, or something like that. And I would say that's a constitutional obligation, and I think Professor Benjamin would say that's not only a constitutional, not an obligation, but inappropriate.
Right. So let me, since he's fairly well stated my position, let me just say when I hear arguments based on gravitational forces, penumbral emanations, et cetera, I reach for my wallet. Right. I just don't. I'm very.
That pocket has been picked.
I'm very wary about going down this path. So Professor Young and I worked together on a dissent in a case called Seminole Tribe, And the majority opinion invoked not the language of the 11th Amendment, but background postulates which limited control. And so our joke whenever the clerks, the Scalia chamber would come by was, could we just borrow those background postulates for a little bit, just have some fun with them, and then we give them back, right? I'm off the ship when we start talking about gravitational forces, et cetera, because it just feels to me like then we really are just making it up as we go along.
I just want to add, because I just feel that I'm sure that Ernie and Stuart know this when they say we're playing with the net down and we don't respect the Constitution at all. I mean, it really does. That's not quite true. It really does come down to what do you think. We're not writing Congress out of the picture. I mean, it really comes down to when do you think Congress has authorized action? All of us agree that the agency, Congress can close down any agency whenever they want and say, you just can't act, you're done, goodbye, go home. And the question is, when they authorize legislation, what is the significance of that? Is there a separate authorization needed for federalism? And as I said, that depends on, I think Stuart's position would be you just use the regular tools, and Ernie's position would be, you need more to protect federalism because of these penumbras or whatever. And our position is because of the welfare maximizing ability of the agencies, we would say that we would err on the side of allowing agencies to do that. But still, you have to try. I think we all agree that you have to tie it to some congressional authorization, and then maybe our net varies in height too much for Ernie, but I do think we all recognize there's a net there.
They'd have a little bitty board. That's all. It's not 10.
Are there other questions? Great. Well, please join us outside. Nope. Yes.
It seems like a lot of you have expressed you've expressed aspirations about Congress maybe stepping in to create a statutory regime to sort of give this a lot of legitimacy, that suddenly agencies would have discretion to talk about federalism because they would have explicit statutory authorization, and at the same time undercutting the chances that would actually happen. So my question is, if it were instead the court, if it were the Lopez court, like the sort of more interested in federalism or states' rights kind of post-Rehnquist kind of court, that were to decide that we wanted to suddenly require agencies to consider federalism in a new way, that are we setting ourselves up for like a series of City of Bernie v. Flores decisions, like lots of, hey agencies, you can't do this anymore, hey agencies, you can't do that anymore, and how much strain would that put on separation of powers horizontally just within the federal government in order to try and create some vertical separation of powers?
I'll jump in first. I think there's a significant difference. I think you're right. There's going to be crimping, right? Any of these approaches is going to be a pushback on the federal government. But I think there's a significant difference when you have the court saying to an agency through an administrative law framework, you can't do that. Then when you have the court saying, as you do under Section 5, that's outside of your constitutional power. I mean, then the door is shut, right? And this gets to some of the analysis and commentary on the Section 5 that one of the things Congress, the court did was deny Congress any role in sort of any kind of dialogue in developing the norms and substance of the 14th Amendment, right? But that's what that constitutional decisions do. And similarly, quasi-constitutional clear statement rules erect an even greater barrier because the whole point is to make it hard for Congress to act. Congress has a hard time legislating, and now you make Congress legislate with degrees of clarity that are sometimes, in terms of what degree of clarity is required, isn't so clear. And that's basically an obstacle that's hard for Congress to overcome. I think if you use administrative law, there's an obstacle, but it's not as significant. And I should say that's probably, you'll get people on the ossification side of administrative law who would debate that strongly. So that's a debatable proposition. But I just think it's possible for Congress to overcome it. I think it's possible for agencies to overcome it. And I think the important point here is that agencies have to respond to this kind of judicial review all the time. And that doesn't mean that it's not a burden for them, but I don't think it's of the same order of magnitude.
Yeah, if I could just add, in our paper, we explicitly talk about the fact that because the burden of responding is lowered, we think Brian and I think that you can create more discourse that way to the extent you think discourse is relevant, rather than just in 1789, here was the structure as we see it, and that's it. So if you think that this is not an issue where majoritarianism is not particularly relevant, we think you can get more majoritarian discourse because there are, as Gillian mentioned, the agency can come back and say, okay, you didn't like that explanation. We can still give you another explanation and maybe convince you. We can change what we did a little bit and modify it, and they do that all the time in response to these hard look cases. Congress can come back and say, let me make it clear, we really did mean to let the agency do this. And there's just, and the states actually have a role because as I guess probably consistent with what Ernie told the states today, the states can construe these and say, look, we have an obligation, state courts and legislatures to, at least the courts have an obligation to uphold federal law, and the legislatures probably do under the Supremacy Clause as well. But they can construe that very, very narrowly and say, well, we still have the right to do X, Y, and Z. And that's going to come up through a state court and then go to the Supreme Court, or the agencies or Congress is going to have to act again. So the point is, if you lower the costs of responding, we think you can encourage discourse rather than dropping the A-bomb every time and saying, well, now you need a constitutional amendment. I mean, one of the things that Ernie did with his sort of resistance norm is to say, well, we don't go that far. We can let Congress do it. Well, we're just lowering it a little bit further and saying, oh, well, let the agency do it. Rather than, now we don't even need the Dresden bombing. We can come back to a reasonable response.
Can I add something to that? And I take a more a position that would require more action from Congress. So I would take the position that you ought to have some greater clarity from Congress before a statute should be read to give an agency the authority to preempt state law. So I would not go as far as Professor Seidenfeld and Galle. With that said, we're very far away from Dresden bombing or whatever analogy you might choose to use. There are already statutes on the books that are quite explicit in saying, here's when agencies can preempt state law and here's what criteria they should apply. Arguably, one example of that is the Clean Air Act provision I mentioned earlier, but there are lots of other ones on the books. It's not that easy, and but I think it's worthwhile because one of the reasons we do, in other settings, apply a presumption against preemption of state law is to prompt explicit discourse in Congress about how much preemption of state law there ought to be.
Great. All right, please join me in thanking our participants.